Any time off for this one?
Yeah, towards the end of July.
Shelley?
Go ahead.
All set. Good morning. My name is Ed David, and on behalf of myself and my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases, and they will not be considered further today. So looking at the agenda.
I actually, before we vote on the agenda, I got a last minute request to withdraw a case, which I'm going to recommend that you deny because I don't have a signed withdrawal or anything, and it's been on the agenda. And we have a submission of disagreement from the complainant. So it's Warner versus True Value, which is E22-0220. So I literally got it this morning as when I opened my computer. So I would need a motion on whether or not to reject her request to withdraw her complaint. I do suspect that she won't be here today. Yeah, Mark.
I would move that we reject her request to withdraw her complaint.
Second. Julie. It's been moved and seconded. Any discussion? Seeing none, our remote participation policy requires that the commissioners indicate their vote both verbally and visually. So I ask you to state your vote and either raise your hand. No, we did discussions. Great. Okay. If you vote yes, you are in agreement with the motion to reject her request to withdraw her complaint. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Great. Okay. All right. So now we can move on to adoption of the agenda and the consent agenda.
And I will move adoption of both.
Second.
Moved and seconded. Any discussion? Seeing none. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Director's report.
Minutes. I have a motion to adopt the minutes from the May meeting.
So moved. Second.
Moved and seconded. Any discussion? None. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay. So for personnel, we have hired a new Secretary Associate Legal to fill the position that Chelsea vacated when she moved to Business Manager. She will start tomorrow. Very excited. She wanted to start today, and I said today might be kind of a day it starts, and that's going to be in a meeting from 7:30 to 3. So she's starting tomorrow. She is very excited.
And what's the position?
Secretary Associate Legal. So it's Brittany, Jennifer Manzano-Ruz, and Chelsea used to be in that position until she moved to Business Manager. So they process all the complaints, they process the intakes initially, they open the cases, close cases, do make sure the agenda for the meetings go out. It's a lot. We do not function without them, and it's been hard only having two. So Chelsea will get to move more fully into her position, and the new person gets to return all the phone calls. That's what the new person has to do. No, Jeff has my personal cell phone number, and that's how he calls the commission when he needs to, apparently. I just also, actually last night. I think whoever's in recruiting has been working over the weekend, so I just got the applications for the investigator position, so we'll be reviewing those and doing, well, that's gonna be fine. I'll speak loudly. So we're gonna be reviewing those and we'll be offering interviews probably in the next week or so, and hopefully we'll have a new investigator starting by July. Fingers crossed.
And we're one down.
Well, we are technically 2 down because Colin is reclassifying his position to a council position. So once that is finalized, which we hope will be soon, BHR did their audit last week, which usually means it moves pretty fast after that. Then we'll post another investigator position. Once we hire that investigator, then we might be fully staffed for 5 or 10 minutes.
So Colin is associate counsel,
Colin is deputy counsel.
deputy counsel.
Yes.
And moving out of investigator. But you can't advertise that yet, or?
No, not yet. Not yet. We gotta wait for BHR again. And they are, I gotta say, like, they're doing a huge amount of work with like 2.5 people. So I keep offering to bring them snacks. Thus far they have declined. Conciliation, you have a memo from Jane. I guess maybe it's actually from me, but it's really from Jane. 5 active conciliations, 1 successful, 2 unsuccessful, and I need a motion to approve the agreement in E22-0029 James v. Portland Air Freight, and also to let me sign for you. So,
Second.
is that you, Commissioner Douglas?
It was.
Okay, great. Moved and seconded. Any discussion?
We just did this.
Yeah, this was recent. All right. None. If you vote yes, you are in agreement to approve the agreement. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders. Yes. We have had 53 new complaints in May, 38 administrative dismissals. 16 of those were settlements. 3 settled in our mediation program, 13 were private settlements. This is again high for the same reason that it was last time. I have been attempting to track down terms from people and people have been responding, which is great. So for those 16 cases, we have a total of $443,986.36 to complainants. Questions about any of those? I would ask we take litigation in executive session. New business, not much. The legislative session ended without any of the bills that were sort of put forward. None of them were enacted. So our bill did get moved off the appropriations table and passed by the Senate.
It's still not active.
And still is not enacted, so we will be trying again next term. I have learned some valuable lessons, which is do not attach a fiscal note to a straight up statutory change. So we will be proposing 2 bills, 1 to correct the law, 1 to change Barbara's position. Actually, we will be proposing 3 bills because I will be, I promised the mediators I would see if I could get them exempted under the Maine Tort Claims Act. So I will be proposing that we treat them as employees just for the purposes of the mediations they conduct, so they don't have to carry quite so much liability insurance. We are coming up on the end of the HUD fiscal year and the EEOC fiscal year. HUD ends at the end of this month. EEOC ends at the end of September. I am happy to bore you with as many details about that as you'd like to hear or not. Any questions? Great. Okay, that's all I have for reports and new business. Any questions? Take 5 minutes.
Sure. So we'll take 5 minutes and commence the cases for hearing at 8:45.
get into it, I forgot to have you approve the conciliation dismissal, so we'll do that first. Okay, so before we get into the hearing agenda, I forgot that Jane has given you several memos recommending dismissals of cases that have fully complied with their conciliation agreements. I think we can just take them as a group. So can I have a motion to approve dismissal of those cases?
So moved.
Okay. Moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Great. Thank you very much. Okay. And do you want to give us the rest of
okay.
your?
I'm sorry, I
That's
was
okay.
lost in my iPad. I thought it wasn't working yet. It's because it was on a blank page of
Oh, no.
of the case that we're talking about. So according to the agenda, it's the PA Cookson versus Maine State Prison.
Yes.
Yeah. All right. The remaining cases on the agenda for today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. And as I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments in the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the report of facts submitted during the investigation, or three, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium. So that being said, the first case is PA 22-0233, Jeffrey Cookson versus Maine State Prison. The investigator's recommendation is for a finding of no reasonable grounds, and therefore we would hear from the petitioner.
I'd just like to remind everyone before we get started to please not use the name of third parties. If we've given them pseudonyms in the investigator's report, please use those. Otherwise, please refer to them either by their title or by the type of entity or something like that. The MHRA requires the commission to maintain those parties' confidentiality, so we're asking those presenting here today to do the same. Do we have Mr. Cookson on the phone? You're on the phone. I believe Mr. Cookson is going to be with his caseworker. If you're on the phone and you need to unmute yourself, if you push *6, that should do it.
Yes, I'm on the phone.
Okay, Mr. Cookson?
Yes.
Great. Whenever you're ready, you have 10 minutes. Do you want to save any of that time to respond to Attorney O'Brien?
Yes, I do, please.
Okay, how much time would you like to save?
At least 5 minutes.
Okay, you have 5 minutes now then, whenever you're ready.
Okay. Well, I would like to state I had sent a paperwork in rebutting the investigation report. The board did get that, correct?
We did, yep.
Okay. I would like to just have the board recognize that, because it's there's a lot in that investigation report that was not investigated properly. So I guess that's all I have for now.
About 4 minutes. Yeah, no, sorry, 9 minutes. Yes, that was 50 seconds. I can do math today. I'm going to need some more coffee. All right. Any questions for Mr. Cookson from the commissioners? All right. Seeing none, Mr. Cookson, you'll have about 9 minutes when we come back to you.
Okay.
All right. We don't need to mute the phone but Attorney O'Brien is going to present, and you may not speak while she is presenting. Okay.
Okay.
All right.
Good morning. My name is Jill O'Brien. I'm an Assistant Attorney General, and I represent the respondents, the Maine Department of Corrections, and Heather Richardson. There were 3 issues that Mr. Cookson brought before the commission regarding his access to a shower, regarding access to telephones, and access to a legal assistant. We provided the investigator with photos of the relevant phone and shower areas and a description of Mr. Cookson's litigating his habeas petition ably himself and communicating dozens of times with the medical department quite capably. I'm here to answer any questions the commission may have, but otherwise we agree with the investigator's report, and there is a very robust record. Commissioner O'Brien.
Just one question. You didn't mention the laptop. Is that one? And you said legal assistance.
That is true. Apologies, it's been a long record. Laptops are provided to residents in the education program only. Mr. Cookson is not in that program, and he's had some discussions with Ms. Getz, a person who runs the education department, about his need for medical documentation, if that is one of his needs. And I believe the investigator asked him directly to provide that medical documentation, and it's not there.
Any other questions for Commissioner David?
There's discussion about the ADA. If it's in the record, is the text of the ADA relevant? Does it have specific dimensions, or does it just talk about the access that's required?
There are lots of implementing regulations for showers in the ADA, but it's our position that 2 shower bars and a seat are sufficient.
And that's because of your reading of the ADA? Is that in the record? That definition is in there?
It's in the investigator's report that the investigator relied on ADA standards for accessible design for 2 bars and a shower.
Okay.
Oh, seat, excuse me.
And his complaint is that not that there's not 2 bars in the shower, but that's not sufficient. Is that what you understand his complaint is?
The complaint as originally formulated was vague on what exactly he required from the shower. The department believes that as it is currently functioning, it complies with the ADA. The focus of the complaint, I believe, was really the laptop.
Commissioner Sanders.
Yes, does the Maine State Prison have policies in place that would bar an investigator from coming on site to visually inspect the physical circumstances in the prison?
No policy prohibiting it. It would be subject to the warden's discretion, and I don't imagine he would use any discretion against that. There would certainly be timing limitations, and there are times when the entire facility is locked down if there is an incident, if someone is hurt. But if that was something the commission was interested in pursuing, we could certainly look into that.
Any other commissioner questions for Attorney O'Brien? Seeing none, you'll have about 9.5 minutes when we come back to you.
Thank you.
Mr. Cookson, if you want to unmute yourself, again, it's just *6. You have 9 minutes and 10 seconds. All right.
Okay. The AJ said that there wasn't no medical documentation after I talked to education, that they recommended that I get documentation. I did go to the medical department. The medical department would not send me out to have a consult to back up my claim on that. So that's the reason why there's no documentation concerning the cognitive issues and whatnot. As to the shower rails, the Department of Corrections, I believe I sent that to the board about the shower rails. The U.S. Attorney General's investigated that before I filed the claim with the Human Rights, and they suggested that and told the Department of Corrections to put rails 75% round in that shower, so meaning that it would be on 3 sides of the shower. That's all I have.
Any commissioner questions for Mr. Cookson? Commissioner O'Brien?
Mr. Cookson, I don't know why I'm focusing on the laptop, but I am. And I am confused. I'm not real big on technology, but what you said that would not work for you. Why particularly do you think a laptop would work better?
Well, what happens is the mobility that I have to be pushed around to the rec department and most every place that I go, medical and whatnot, in a wheelchair, and then the computer room in the education is not feasible. That's why I addressed that part in the rebuttal to the investigation report. That computer room, you can't even get in there with a wheelchair, and if you did, you're crammed in there, so you can't even move around. What I have. The computer, a laptop would benefit me. I wouldn't have to leave my cell, and it would benefit me greatly for cognitive issues that I have and memory losses and whatnot. That's all I have right now.
Mr. Cookson, did the investigator interview you? Did he talk to you?
Absolutely not. They never even come and see me.
Didn't come and see you. Did he talk to you by any other means?
There was a phone conversation, one initial phone conversation. That was all it was, just a couple of minutes. He said he would investigate the claim. That's the last I heard from him, other than the last report that he wrote.
Well, I'm unclear what you think he did not hear from you or investigate in terms of your allegation.
Well, he didn't. He did not investigate the computer room, the computer room whatsoever. He did not investigate the response that I told the board and him about the medical department not wanting to send me out to a specialist for what they wanted as far as a report from.
Thank you.
Any other commissioner questions for Mr. Cookson? Thank you, Mr. Cookson. We're going to mute you now. Attorney O'Brien, you have 9.5 minutes if there's anything else you'd like to add.
Thank you. This feels a bit backloaded. I have not seen any documentation about an ADA investigation of showers at Main State Prison, and perhaps this was raised in the last month, but it's not something that's in the record as far as evidence goes. The department disputes that the computer room is accessible. We very much believe it is. Mr. Cookson is very active. He participates in industries. He works in the wood shop on a regular basis, and he is able to push himself there, get himself there, work in the industries program using both of his hands and very capably moving his wheelchair there. I don't represent WellPath. WellPath is not a respondent in this matter. All of the prison's medical decisions are made by WellPath providers, so they haven't had a chance to weigh in here either. The fact of the matter is that without some sort of documentation, the education department, they can't go look at medical records. So it's up to Mr. Cookson to show that he has something that needs to be accommodated that the prison is not doing. That hasn't been shown here despite a specific request for it by the investigator. If there are no further questions, I'll rest.
Commissioner Sanders and then Commissioner O'Brien.
Thank you very much. Just so I understand, WellPath is the external medical provider for inmates at the prison.
And I'm sorry, if WellPath isn't a party of the case, we should use a different name for it.
Understood.
External medical provider.
Internal in the sense that they have dozens, if not hundreds of staff on site daily who report to work there every day. So the medical care is contracted through them, a separate entity, but they are physically internal on site, doing administration of medication, checking blood sugars, constantly interacting with residents.
And with respect to Mr. Cookson's complaint, are those staff on site in the facility qualified to opine on the presence of and extent of a disability that an inmate may have?
The factual basis for they have physicians assistants. It's a legal determination, right, if someone is disabled, but certainly medical professionals there regularly document, for example, that Mr. Cookson needs a wheelchair.
They'd be able to generate the medical opinion which would support a designation of disability, correct?
That's right.
Okay. And what do you make? Mr. Cookson alleges that medical staff on site have either been resistant to or prison employees in particular have been resistant to obtaining a determination of disability. How do you respond to that?
So without knowing what those conversations were, it is difficult to know what he's referring to. I believe what this is generated from is the education department saying, please ask your medical provider to provide me with some documentation in support of the laptop, and specifically suggesting that an occupational therapist might be helpful. I believe Mr. Cookson saying he asked for an occupational therapist and they said no, but I don't know who he asked or when or what the basis for that decision-making was.
And that wasn't part of your investigation into the allegation?
So we provided the information that the education worker had the discussion with Mr. Cookson about an occupational therapist. This additional information is new this month. I believe Commissioner.
I think, on a broader sense, I have always been under the impression that the state can't be sued, and is the prison as an extension of the state. Am I correct on that? So he has put as Heather Richardson in the prison. Talk about.
Sure. Under the Americans with Disabilities Act, the state may indeed be sued.
Okay.
So to the extent that makes whether the state can be sued under the Human Rights Act is a separate question, but we are not contesting jurisdiction right now.
Okay, thanks.
Commissioner Douglas.
Good morning. Good morning. I was just curious about something Mr. Cookson said about the computer room, right, where he's trying to get his wheelchair in and he can't get it in there. You said you dispute that. I mean, can we talk about the computer room a little bit more? How big is it? You know, how easy is it for him to get his wheelchair in there, this sort of thing?
As much of it is in the record.
None of this is actually in the record. Didn't raise that issue during the investigation. This is the first time.
Okay.
Thank you.
Commissioner questions? Right. So we've heard from the parties, and next we will hear from Colin, who investigated this case.
Morning, Commissioners. As you know, I am Colin Hurd, and I was the investigator for this case. First off, I just wanted to point out that I did correspond with complainant multiple times via letter. He had multiple written submissions that he sent to me, and we also corresponded via request for information that I sent him, where I asked a lot of questions of trying to confirm his claim and whether or not it fit within the analysis that I needed to do. About the issue with the laptop, something I wanted to address was that in addition to there being no medical documentation saying that a laptop was necessary for his disabilities in this case, he also did not state that he needed the laptop for access to respondent services programs or activities. I don't remember exactly where it is in the report, but he mentions that he really, I think, wanted it either for access to legal services, but primarily for personal reasons, for corresponding with his family. It would have made those things a lot easier. And I'm not sure that those things qualify as respondents' services that they provide. And it's important to keep in mind that they're a public entity, not a standard public accommodation. So the standards are a little bit stricter in this case. Regarding the ADA standards, those are in the record, but they were not submitted to me. They were something that I looked up personally when he did raise in one of his letters the issue about the shower, which prompted respondent to send me the photo. So yes, according to me, and I footnote 13 is the citation of the ADA standards that I used to determine that for showers, it's 3 bars, so 1 bar on 3 walls if there is no seat, but if there is a seat, it only needs to be 2 bars and they need to be abutting that seat. And then finally, just for the record, I wanted to point out, just to address one of the allegations and complainant's submission of disagreements, that I do not, in fact, know any of the staff in the same prison. I don't know anybody who works there. That's all I have. I'm happy to answer any questions.
Commissioner questions for
Colin, how many staff at the prison have you been hanging around?
0.
I withdraw the question. Yeah, so just to follow up on what I asked Attorney O'Brien, complainant never raised any issue about the accessibility of the computer room.
No.
Alternate set of his desktop
No.
computer.
The only issue he raised about the tightness of space as far as the wheelchair was regarding the phones, which is addressed in the report.
All right, thank you.
And if I miss something going forward that's not on the record, feel free to wave madly or throw things at me.
Make sure you only hit Kit.
Commissioner David.
His access to phones is just the same as everybody else's, is that fair to say? Is that your conclusion?
There are 2 phones on his level, and at least one of the phones, I believe it's only one of the phones. There was a photo submitted to me that shows that it's definitely would be if somebody in a wheelchair was at that phone using it. There's 2 doors on either side, so there's the phone in kind of like the middle of the wall, and then there's 2 doors on either side that kind of swing into the space. So if he was at that phone and both doors were to open or close simultaneously, then it might come in contact with his wheelchair. But if both doors are closed, or if one's open, one's closed, or whatever, but I don't think it restricted his access to the phone. It just sort of made it less convenient for him. And also, it was not the only phone. There were 2 phones on his level for disabled access.
And in talking about the phones, I think there were 6 on his level, right? I mean, 2 phones.
Yeah.
For 6 people. Are the inmates allowed to, is there a specific time that they're allowed phone calls or?
I don't know.
Okay, all right.
Any other commissioner questions for Colin? Seeing none, thank you, Colin. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are 2 proposed times. Commissioner O'Brien.
Yes,
you are
I'm right on it.
Great.
I well, there are no reasonable grounds to believe that namesake prisoner Heather Richardson discriminated against complainant on basis of age, and there are no reasonable grounds to believe that namesake prisoner Heather Richardson discriminated against complainant on the basis of disability, and the complaint should be dismissed.
Second.
Moved and seconded. Any discussion? Seeing none, motion is to find no reasonable grounds on both recommendations. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Thank everybody for their participation, and the commission will send a letter to the parties confirming the results.
The next case is E22-139, Halliday versus Connectivity Point Design and Installation. The recommendation of the investigator is for finding that there are reasonable grounds. Therefore, we would hear from the respondent.
Attorney Haley?
Yes.
Good morning. 10 minutes, do you want to reserve any of your
I
time?
reserve two.
Thank you. Ready? Go ahead.
Good morning. My name is Brooke Haley. I represent the respondent Connectivity Point Design and Installation. And upon a review of the investigator's report, I do think that there is a factual error here. The finding is based on the determination that there is a disparity between the reasons for discharging complainant, Mr. Halliday, and a single post-termination statement made by one of respondent's employees. We'll call him the department manager. And that statement was in January 2022 that he said that he can't talk openly about HR issues, but he knows that Mr. Halliday was trying to come back at a limited capacity and didn't know whether there was a date planned for his return. So the report suggests that this statement means that the department manager did not know that Mr. Halliday's position had been eliminated, leading to an inference of pretext. However, in reaching this determination, it's our position that the investigator failed to consider relevant evidence, including testimony presented during an Issues and Resolutions Conference, which included relevant testimony by that very department manager. So during the Issue Resolutions Conference, that department manager testified that at the time of that January 2022 meeting, that all communications went through HR at this time, and he had no direct correspondence with Mr. Halliday. He also testified that he was not entirely sure whether the company had made any official announcement regarding Mr. Halliday's employment or how they were going to have that done. He further testified that following the January 3rd meeting, he went to HR and asked, "Where are we?" And then Human Resources was able to update him and the team. So there's certainly no question that he knew that the position had been eliminated. And he knew that the position had been eliminated because he was one of the decision makers. In September of 2021, he went to HR and said, "I'm having a difficult time. We need someone to backfill this position." So he and the director of finance and HR decided that they would transition some of the AV project manager duties to an existing AV tech. And then they found that that AV tech was able to do 50% tech work and 50% project management work. And so in October 2021, they decided to eliminate Mr. Halliday's position. So the department manager was part of that decision. There was also some confusion because it was never Connectivity's intention to simply eliminate or terminate Mr. Halliday. They did let him know that he was welcome to apply for any available positions. So I think at that point in January, the invitation was still open to apply for any available positions. And certainly the department manager would have wanted Mr. Halliday to do that if he found an appropriate position. So it's unreasonable to infer that any reference to a potential future return by an employee who was a well-performing employee and who would be welcomed back at any time is pretext for discrimination. Connectivity was simply leaving the door open for him to apply for an open position in the future. And unless there are any questions, I'd be happy to address.
Questions for Attorney Haley? Commissioner David.
Seems to me that the crux of the investigator's recommendation is that there was a lack of a interactive process here, which is required in terms of accommodation. Is that not correct?
It's not correct, and I don't believe that that was part of the report. I think the investigator found that connectivity could have been more responsive in communicating to Mr. Halliday that his position was eliminated, but that the report said that that's not really part of the analysis. Mr. Halliday's position was eliminated in October of 2021, and the report and recommendation does find that that is credible.
They filled the position before that, did they not?
Well, it was interesting because the current department manager was previously a project manager. He was promoted in June 2021 to department manager. So
Which is
his,
what the complainant's position.
yes, so the department manager's former project manager position was filled in July 2021. So then there was still a need for project manager duties, and they found that they were able to roll that into an existing AV tech position and have that AV tech do 50% tech duties and 50% project management duties. And then so they eliminated Mr. Halliday's project manager position.
Yeah, I'm curious about the communication that the respondent had with the complainant around, very specifically that his position had been eliminated, but you say, right, and it's in the record, he was welcome to reapply. I presume that means that he was welcome to reapply through a competitive application process. Is that sort of very specifically what was communicated to him?
Just that if there was an open position that he thought he was qualified for, he was welcome to apply. And at the time that he said that he thought that he might be able to come back to work, which we don't know whether he was actually able to come back to work when he said that he was able to. I think Mr. Halliday has continued to struggle, so I don't know how much he would actually be able to work. But there was only tech positions open that he would not be qualified for.
To the extent that that interactive process was continuing, wouldn't it have been appropriate and compliant with the disability accommodation law, both at the state and federal level, to rather communicate to him when he was ready to return, he would return, not having to engage in a competitive process for a position of the entity?
I think it was kind of just casual conversations at this point because Mr. Halliday was not able to come back to work. So the director of finance and HR said that we've eliminated your position, but when you're ready to come back, if there's an open position that you're interested in, just please get in touch and let me know. And Mr. Halliday never expressed interest in another position.
Has respondent acknowledged through this process that upon termination of employment, under these circumstances, more is required than a casual conversation with the complainant?
Yeah, I think they recognize that probably the communication could have been clearer. They let Mr. Halliday know in September that they were having a hard time of keeping the position open. They let him know in November that his position had been eliminated, and certainly welcomed him to engage in further discussions. But Mr. Halliday also declined to engage in further discussions.
Commissioner questions for Attorney Haley?
Commissioner David. The company is growing and they're adding 80 technicians, correct? They clearly have need for that position.
In what time?
I don't know. Tell me.
The report and recommendation did find that the AV department had downsized, and that was credible. And there's also a difference between tech positions and Mr. Halliday's position as a project manager.
So what is the most important thing that you say the investigator got wrong?
That there was an inference of pretext based upon a disparity between the reason for eliminating complainant's position and a single statement by the department manager that he wasn't sure whether Mr. Halliday was coming back. And that communication was just simply that the department manager didn't know what HR had already communicated to Mr. Halliday.
Wasn't there more than one indication that he was still he was receiving emails, he was receiving communications, other people thought he was coming back? Aren't there several indications of that? No,
Not that I'm
I made that up.
Well, he was still on email distribution lists after he was let know that, that his position was eliminated. He continued to receive short-term disability benefits until December 18th, 2021. And those were simply kind of pre-populated email lists.
And you would concede that it would be unlawful discrimination if, in fact, the real reason to not engage with him and to let him go was the length of time that he's been out on disability, right? That's not a proper consideration.
His disability would not be a proper consideration, correct?
I mean, it is striking that he's out for 21 weeks, I think. But that's, okay.
Yeah, and this is.
You don't mention it, and that would not be correct.
And this is, just kind of a unique time that we're still right in the throes of COVID, and there were supply chain issues, and the department it downsized during that time and had been using a lot of subcontractors prior to COVID, stopped using those subcontractors, downsized the department, and they didn't, increase the department until well after the position was eliminated.
Sure. So when the decision was made, I believe you said in October, and then communicated to the complainant in November that his position had been eliminated. So I understand that timeline. I'm curious about, is there any documentation, maybe it's a better question for the investigator, but is there any documentation in the record to reflect that in October, respondent engaged in further discussion with the complainant about whether a period of additional leave would be appropriate and called for under the ADA or MHRA?
I think there were communications throughout Mr. Halliday's leave, and I believe, I don't remember when the last communication was, but that there was a communication that he would be out until at least November. And then when Mr. Halliday got in touch around November 22nd and said, can we talk about my return to work? That's when the director of finance and HR let him know that his position had been eliminated.
Sort of drilling in on that though, is there any internal work product or correspondence that perhaps the director of finance or the director of HR produced, which documented the reason for denial of an additional period of leave under the ADA or MHRA?
I don't believe that's in the record.
No. Any other commissioner questions for Attorney Haley? Seeing none, you'll have 7 minutes when we come back.
Okay.
All right, Mr. Halliday, do I understand that you have counsel now? And if so, are they on the call?
Hi, no, my counsel is not on the call. I only engaged with them in settlement talks. I've been representing myself through the commission process.
Okay.
So it'll just be me here today.
Okay. You have 10 minutes. Do you want to reserve any of your time?
Yeah, I'll reserve. I should only need about 5 minutes, so I'll take any 5 that's left.
Okay, great. Whenever you're ready, go ahead.
The first thing I'd like to do is just address a couple of points that were just made that were not accurate. One was that there were only tech positions available, which is not true. Through the course of the process, I've documented 3 different positions that were available that I would have been qualified for. The second was related to the keeping me on the company email and distribution lists through my short-term disability. That was not just through my short-term disability ending. It was until March of the following year. So in 2022, I had complete access to my email and all company property as well. So even after that January decision, uncertainty that is being presented, I still had all of that, ability. And then the last part was just about the communication piece. So after I was informed on the first, the September 1st about the struggle to keep my position open, I received, there was no communication until the day before I was scheduled to return to work. And I had reached out in the middle of October to provide the return to work date as well as the requirements for my return to work. And I received no response to that as well. So if the decision was made in October, the beginning of October, that my position was no longer needed, but then I provided information in the middle of October, this is when I was supposed to return, I had no reason to expect that wasn't the case. So those are just some points that were just made that are I found to be untrue, inaccurate. But really, what I wanted to say was that the findings of the investigator should be affirmed because the appeal is really more for a reason of a reinterpretation of a statement that was made. The respondent is not asserting there are any factual errors. There is no relevant facts that were left out, and there is no issue or concern regarding the interpretation of any law. The investigator considered the complete record when making his determination, including the testimony at the IRC. It was determined that the respondent had contradictory statements as to the timing of the decision to eliminate my position. And then when asked to produce any documentation to show decision-making process, respondent did not provide any. It's based on those factual findings that the investigator found the pretext. As initially stated, the respondent argument is that to appeal the findings is based on an interpretation of my supervisor's IRC testimony. Even if the testimony is reconsidered, it still does not change the factual discrepancies of the timeline and the lack of engagement to find any alternatives. So then, as a result, I respectfully request that the commission affirm the recommendation by the investigator to find that the respondent discriminated against me based on my disability. That's all I need. Thanks.
I've about 6.5 minutes. Any questions for complainant? Commissioner David.
They did not communicate with you that they said they had eliminated your position?
The only between September 1st and November 21st, when I reached out to them to say, hey, I need to discuss my return to work, I heard nothing from them. It was only on November 24th, the day before Thanksgiving, where I was going to return the following Monday. That's when I was informed that my position was eliminated. And that the only thing that they had available for jobs at that time were technician jobs, which was inaccurate.
And the crux of your complaint is that this is elimination of saying the position was eliminated as a pretext because they wanted to let you go because of your disability, right?
Yes, that, and that there was no engagement in any interactive process beyond that. You know, if they wanted to eliminate my position, okay, I understand that as a business decision, but there was also no attempt to engage in anything beyond that. So I don't think either thing is, believe both of those are obvious discrimination actions.
And you question whether there was a downturn in business that would have justified eliminating the position?
Well, yeah, I mean, I had complete access to my email, so I could see everything that was going on. And, you know, one of the functions of my job, one of the major functions of my job was procurement, you know, purchasing and everything. And if that was a thing that was slowing business down, my, 5 years of experience working with all the vendors would have been invaluable in a situation like that, especially my knowledge of the industry and the technology. I would have been able to assist in finding solutions. I had relationships with so many of the vendors. I just would have been an asset in many, many different ways. Even if, the claim that work had slowed down was true, I still would have been useful.
Thank you.
Any other commissioner questions for Mr. Halliday? Seeing none, Mr. Halliday, you'll have about 6.5 minutes when we come back to you. Attorney Haley, you have 7 minutes if there's anything else you'd like to add.
Thank you. With regard to Mr. Halliday's discussion of 3 positions, although they weren't specific, I think that he's referring to 2 AV estimator positions and 1 national project coordinator position. And the AV estimator is a specialized role that was distinct from complainant's role as an AV manager, and complainant is not qualified for that role. And the national project coordinator is largely administrative and had a salary of $57,000, which was significantly less than Mr. Halliday was making. Also, I wanted to add that in her November 24th communication to Mr. Halliday, the Director of Finance did say, we don't currently have any openings for that type of work. We have openings for field technicians at this time. If you would like to discuss your suitability to fill one of those positions, we can certainly discuss. Otherwise, if and when other positions become available, you're welcome to reach out to us. And Mr. Halliday never reached out with regard to any of those.
What's the date of that?
November 24th, 2021. Mr. Halliday never reached out with regard to any of those positions. I did want to note that the investigator did find that the respondent was credible and presented evidence that there was a downsize of the AVO department, which showed substantial decline in work hours that occurred after the first quarter of 2021 and only increased again in the second quarter of 2022. And that was nearly 6 months after complainant's separation. The investigator further found that the AV manager position was diminished quite dramatically during this time, and that a technician was able to assume the AV manager's duties on a part-time basis. Also, I do think the interpretation of the factual record is important. I think the investigator should have considered that department manager's own testimony about what his meaning of the statement in the June 3rd, 2022 meeting. It was not that he did not know that the position had been eliminated. It was simply that he did not know the timing of communication. And while yes, connectivity point should have been or could have been more communicative to Mr. Halliday, I think that they were also leaving open possibility that perhaps work would increase by the time that he was ready to come back. And so they were hoping that there would be an available position for Mr. Halliday, but there just wasn't at the time that he said that he was ready to come back.
So I asked you a minute ago when you first presented, I said, isn't the crux of this case that they didn't engage in an interactive process? And I believe that you said, and this is my question, didn't you say to me, oh no, that's not necessary because they downsized? I mean, isn't that the point? Isn't the question whether that's a pretext or not to avoid the fact that they didn't engage in an interactive process?
Well, it was that when Mr. Halliday was ready to come back or said in November, can we talk about my return to work? There was not an open position for him at that time, but the messaging was very clear that Mr. Halliday
and the
was
message that you just quoted is November 24th when he said, I'm ready to come back. And they said, no, you're not coming back here because we don't have your position. Okay, I got it. Thank you.
that the position had been eliminated.
Yes,
That he was welcome to apply for other positions.
I understand.
Commissioner Douglas and Commissioner Sanders.
Morning. So the downturn in business that you said sort of stopped as the second quarter of 22. The upturn that happened at that time, that was forecast well before the second quarter, correct?
I don't believe so. I think the statement from another member of the team in that January meeting was kind of optimistic to keep people's spirits up.
But he's the president, right? He says new sales number is $46 million. Respondent needs to hire 80 or more technicians to meet that demand. We're in growth mode and AV is a big part of that growth, right?
But
are we disputing those statements?
no, they're part of the record, but Mr. Halliday is not a technician.
No, I understand. Field technicians versus his position. But it does seem like the downturn was forecast to go the other direction at some point in 2022 by Mr. President here, correct?
Well, but any downturn didn't change until more than 6 months after the elimination of Mr. Halliday's position.
Okay, thank you.
On that same line of questioning, in Q2 of '22, when business did ramp up, did the respondent reach out to complainant to say, hey, we have need of your services, where are you, we'd like to have you back?
I don't believe that's part of the record. But, you know, Mr. Halliday is still welcome to apply.
But through a competitive process, or do we not know that?
We don't know
Okay,
that.
That's right. Any other commissioner questions for Attorney Haley? None. Mr. Halliday, you have 6.5 minutes if there's anything else you'd like to add.
I mean, there was a lot there, but you know, I did want the first point that came up about the other available positions. The project coordinator position is true. That one was available. There was another one, I couldn't find the date, but it was an account executive position that was available, which I believe was posted in the October timeframe. Additionally, I'd like to read the very first bullet point in the skills, experience, and training of the shoot, I'm sorry, I just lost it. Here it is. Of the project engineer position that they mentioned, that was 2 openings during my time out, including one new hire who started on the same day that I was supposed to return. The very first bullet point is for the project audiovisual estimator, so an engineer, high school diploma or general education degree with minimum 5-year industry experience in audiovisual system sales, management, service, or installation, or the equivalent combination of education and experience. I'm more than qualified for that position. My resume goes back almost 20 years in the audiovisual industry, and I was performing a lot of those duties adjacent to my role as a project manager as well. So that is definitely another inaccurate statement. The other piece was the talking about the downturn in work. The documentation that was provided regarding the downturn in work was relevant only. They only provided documentation for the regional area, so basically New England, which I had additional responsibilities throughout my time there of managing work around the country. And at the time of my medical leave, I was the lead project manager on several of the largest AV projects they had ever undertaken in South Carolina as well. So while there may have been a downturn there, some of their largest projects were still underway in other parts of the country. So I think it's misleading to say that work, even if it had turned down in one part of the country, may not have slowed down everywhere, especially when work had already been approved as well. And I think that's all I have for the moment. Thank you.
Commissioner questions for Mr. Halliday?
Yes.
Sure, David.
Mr. Halliday, you communicated that you were able to return to work just before Thanksgiving, right?
No, I communicated that I was able, my plan to return to work was submitted. I forget if it's October 12th or 14th, but something around the first part of October. I submitted a doctor's note saying I would be available to return to work on November 29th, I believe it was, with an incremental return. So first week, 25% ability, second week, 50, third week, 75, fourth week, back up and going. And so I submitted that in October. And then I didn't hear anything back until the day before the 29th, which was the Wednesday before Thanksgiving.
And that was your plan, to return with incremental increases?
Oh, 100%. I was very much looking forward to it.
And they never acknowledged that? They just told you there's no position here, reapply?
There's no position here, reapply for technician jobs.
Right. Thank you.
Any other commissioner questions for Mr. Halliday? Seeing none, next we will hear from Colin Hurd, who investigated this case. It's the Colin Show today.
He's going to keep you as an investigator.
I know. He's a
mess with me.
Let's challenge Barbara for that.
Thumb wrestle.
Just to be clear about that though, I took over the investigation of this case. I reviewed it essentially. It was one of our former investigators who investigated it, so I was not present at the IRC. But I came in at the end, reviewed everything. I did watch the IRC. So I guess regarding the statement made by manager during the conference that respondent brings up, I guess I didn't completely find that statement so the problem, I guess, is the timing. So that statement was made to the group in January. And presumably that manager who made that statement was part of the decision-making process in October, early October, to change this position to part-time. And then it was, obviously, we talked about so it was October 7th that complainant doctor sent the final doctor's note saying he's good to return on November 28th with these restrictions, and it outlined, how those restrictions would change over time. November 21st, I believe it was when complainant emailed and said, hey, I'm coming back soon. What's the plan? And got the response that, oh no, your position's been eliminated. There was some attempts at correspondence after that. The respondents extended his short-term disability until December 18th. After December 18th, he received another email from respondents saying, that your benefits are done. You no longer work here. This is in December, and then in January. So not only have we've made the decision in October to eliminate the position, complainant's been in communication with them in November and December. And then December 18th, he's officially done because his benefits are over. Then in January, we have this statement made to the group about uncertainty about his return. And this just didn't add up. It didn't line up to me. And it's not to imply, I guess I don't know if the manager, I guess the assertion from respondent is that manager didn't know what the communications were between HR and complainant during that time. And I guess, that can be true, but he should have known that he wasn't coming back. And I guess I don't understand why he would have made any statement at all about complainant in this meeting for the minutes. So with all that said, I think that it left a lot of room for doubt about what was going on for me behind the scenes, added to the fact that there was very poor communication with complainant explaining kind of what was going on. And I didn't know what to make of it. And given the reasonable ground standard, which is a 50-50 standard, tie goes to the complainant, I thought that seems like enough to find reasonable ground standard. And I'm happy to answer your questions. That's my thought process.
Commissioner questions for Colin?
Thank you.
We've heard from the parties and the investigator. At this time, we will be looking for a motion. There is one that was finding. Commissioner David.
I move that we find that there are reasonable grounds to believe that the respondent discriminated against complainant on the basis of disability, and conciliation should be attempted.
Second.
And moved and seconded. Any discussion?
Yeah, I would just say even chance standard, right? And this record is problematic. I think at trial, somebody could find that the stated reasons why his job was not held open, et cetera, are pretext, and that there was discrimination here. So that's why I'm gonna, move to adopt the investigation.
Also, in addition to that, want to call attention back to footnote 13, because I think in sort of a global sense, this case is instructive to employers based in the state of Maine about how important it is to appropriately and comprehensively document how leaves are administered, communication between employees and management, communication plans, generally speaking, internally. So again, just an overall observation about deficits here, which commissioners have previously discussed.
Further discussion? Seeing none, the motion is to find reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
So the findings are reasonable grounds. We're going to thank everybody for their participation, and the commission will send a letter to the parties confirming the results.
Sure. We'll be in recess for 5 minutes. Call the meeting back into session. The third case is Goodwin versus Beckett and the William Fogg Library, E220206. A and B, the recommendations are for no reasonable grounds on two of the findings and for reasonable grounds to believe discrimination occurred against Stephen Beckett. And therefore, we will hear from the respondent.
Yeah, that's also the only finding that was challenged was the interference with regard to Mr. Becker.
Well, it was, so the other two are not
Were not contested.
not contested. And those are the two against the library, right?
All right, Attorney Williamson, you have 10 minutes. Do you want to save any of your time?
Yes, could I just save the remainder of my time for rebuttal?
Sure. Whenever you're ready, go ahead.
All right, thank you. My name is Nicole Williamson. I represent the respondent, Mr. Beckert, in this matter. Full disclosure, I represented him in his criminal matter, so this is completely new to me, so forgive me. But the issues that I see as they were presented in the report was whether my client created a hostile work environment for the complainant and whether he interfered with the complainant's exercise or enjoyment of the rights granted and protected by the Act. With respect to the hostile work environment, my client did not hold a supervisory or managerial position at the library. He was a volunteer trustee who functioned only as an entity in tandem, in conjunction with the other trustees. As such, he had no individual authority over complainant, no individual ability to impact complainant's work environment, and really no individual impact on the day-to-day operations of the library as a whole, period. The conduct at issue was a single occurrence that occurred at a private establishment outside of library hours and unrelated to the complainant's employment. And although in itself it was severe and both subjectively and objectively offensive, I will certainly concede that it had no impact on complainant's employment or workplace environment. My client was placed on leave the following week, immediately after his arrest, and he never returned to the library after this conduct. The investigator's report concludes that complainant established a claim of interference, and it references the alleged interference as follows. That on August 13th, 2021, when complainant reported trustee to the police, complainant overheard trustee state that he wanted to fire complainant. This led to complainant's reasonable concern that trustee would terminate his employment. Even though the trustee was not complainant's supervisor, but a library advisor, he still held significant authority over complainant and could negatively impact complainant's work environment. I did, and I'm not sure if this was redacted from the final report, because I did submit some responses, but I did want to say that I took some factual issue with that in that the complainant reported my client to the police on August 13th, and my client was not arrested until August 20th. The complainant was not present at the police station at that time and did not overhear respondents say anything to the sergeant. Further, it is never alleged by the complainant or anyone else that he was present at the police station and overheard the statement being made. He presumably learned of the comment by reading the sergeant's report of the investigation during the pendency of the criminal investigation. And my client was placed on leave from the Board of Trustees on August 23rd. The complainant's concern that my client would terminate his employment was not reasonable because my client had already been placed on leave by the time the complainant read the police report. As trustee, my client lacked the unilateral authority to terminate the complainant's employment. And I also take issue with the report's characterization of my client holding significant authority over the complainant, as the record contains really nothing to support such a statement. What is my time now?
5 minutes and 50 seconds.
Okay. Then I would just like to add that I represented, as I mentioned, my client in the criminal case stemming from this matter. He ultimately received 2 convictions, and I believe that
Attorney Williamson, I'm just going to pause you there. Is any of this in the record?
Oh,
it is. Okay. Alex is telling me yes. So
I will. It was, yes, I guess that is in the record. Right. And I guess perhaps this is the place to say. All I'm saying is that I recognize the complainant's trauma, and I do hope that we'll be able to resolve this. However, that comes up. I just question the goal of addressing it here.
You'll have about 5 minutes. Any questions for Attorney Williamson? Commissioner Douglas and then Commissioner David.
Yes, Attorney Williamson, good morning. So I'm just, the basis for establishing the claim of interference in the report is, and it says meeting the standard for hostile work environment, right? But it seems that you are contending that the statement that sort of connects this out of work behavior with the workplace is the statement that complainant is going to get fired, which you say complainant was not there to hear, right? And it's sort of unclear how they learned of that statement. So I guess what I'm wondering from your perspective is that if there is some doubt as to whether or not complainant, overheard this statement or how they learned of this statement, what does that do for the interference claim? Does that allow your client to defeat it? I mean, where does that put us?
And I'll follow this up with a question. I mean, I recognize, and I think that the report was saying that creating the hostile work environment in itself was the basis for the claim of interference. And I, to that end, don't necessarily think that the statement made at the police station really would impact whether my client's conduct originally towards the complainant was discrimination. I just, to the extent that it would impact anyone's read on the situation, and to the extent that it would give anyone the idea that my client did actually have the authority over the complainant to terminate his employment, I just wanted to clear that up, because he did not. And so that is, I did not want that to be considered if you're considering the relationship between them. And as far as the library goes, I mean, my client was not an employee of the library, period. And he didn't supervise anyone, period. But as far as that work relationship went, I consider it more of like just a much more tangential relationship between my client and the complainant, that the complainant is overstating my client's ability to impact his work environment.
Okay. All right, thank you.
Well, Attorney Williamson, you emphasized that your client didn't have any direct authority over him. He had more than direct authority. He had authority over the entire library and all of its employees and all of its policies and all of its decisions. He's a trustee. I don't understand how you think that benefits to say that he doesn't have direct authority. He has super authority. How do you respond to that?
I see what you're saying there too, but as well, two things. One, he was immediately placed on leave, and so at the time of the conduct, of course, he was still a trustee and an active trustee, but he was placed on leave immediately thereafter, or as soon as he was arrested the next week. But I guess more to your question, he could not act or do anything without the unanimous vote of the trustees. I mean, if the suggestion that he could, their decisions did not really go towards the day-to-day operations of the library. It was towards the overall mission of the library as a whole. And so,
Okay, I mean, I understand the distinction. I still think that he has authority. That's why he's in the case. It's part of the library. My other question is that you emphasize that on a factual basis, it could not be true that he overheard the statement.
Mhm.
But you do not question that the statement was made? That's my question. The statement's made, even if it's an exaggeration or or factually false that he heard it being made, correct?
I don't deny that the statement was made. And if, in fact, if someone it was not a statement that anyone would have ever known about. It was not serious, as my client knew that he didn't have the power to terminate the complainant's employment. And I mean, if it had not been written up in the sergeant's police report, then none of us would have known about it. The complainant.
Commissioner Douglas.
I'm just wondering if anybody knows if it's in the record as to when this police report actually came out. Because in my experience, it takes a little while for that written police report to actually see the light of day, right? So do we know that?
It's not in the record, specifically when the police report came out, which is why, based on what is in the record, my client was arrested on August 20th. So presumably that is when the statement was made. He was placed on leave on August 24th, which was essentially as soon as the library's attorney could meet with the other trustees and my client. And I guess that's anything else would be speculation. But yes, that was a 4-day period between the statement being made and my client being placed on leave. But when the police report was released as part of discovery, I cannot say.
Let me just try to ask what I asked you before in a more direct way, right? So following up on my last question, if complainant did not hear the statement at the police station, and if there is no police report, right, for him to review during the relevant time period, I know we're speculating here a little bit, but in your view, how is the hostile work environment then created?
Well, at least as far as my understanding from the report, then the hostile work environment would be created because of my client's conduct at the restaurant in itself. And ultimately, this is what I'll say. If it would be harassment under this act for, just for somebody in a like a coworker or someone that just works at the same place as someone else, if they were to be together somewhere else at a private establishment and one coworker, assaults the other one, if that is discrimination under this act, then I would concede that's what this is. And my interpretation is that there needs to be something more than that. And if I'm wrong, then
I was a little worried about you there for a minute, but you got there. Thank you. Thank you.
Commissioner Sanders, did you?
Sure, just pressing you on the timeline a little bit, Attorney Williamson. So you say he was placed, it's in the record, he was placed on leave from the library on either August 23rd or 24th. There's some, discrepancies between your position here today and the record, but nonetheless, and then he resigned on April 11th of the following year. So the complainant would have labored then for roughly 8 months or so, right? While he was, respondent was still in that trustee position, worrying about potential interference with his employment. How do you respond to that?
I don't think that that's that would have been a reasonable worry, because as is in the record, the complainant knew that until he was convicted of a crime, my client could not be removed from the trustee position. I believe it was very clearly indicated to him, or at least to his wife, the library director, also in the record, that was why he was on leave. But the implication being, or that he wouldn't be returning. And I don't want, I guess I can't really speak any further to my client's reason for not resigning until the April date when he actually did resign, because it is not in the record. So I'll leave it at that.
Commissioner questions for Attorney Williamson? Seeing none, do we have Mr. Goodwin?
I think we do. He may be on the, I believe, and I am not certain that he's the 207 phone number at the bottom.
Mr. Goodwin, if you're on the phone and you need to unmute yourself, push *6.
Hello?
Hello. Yep, Chelsea just muted you by accident. If you can hit *6 again. Great, okay. We're just renaming you so we can tell who you are. You have 10 minutes. Do you want to save any of that time?
Yeah.
How much would you like to save?
5 minutes.
Okay, all right, so you have 5 minutes now. Whenever you're ready, go ahead.
I just wondering if the investigators questioned Sergeant Lund on the conversation about me being fired.
I'm sorry, can you repeat that, Mr. Goodwin? We couldn't quite hear you.
I was wondering if the investigators questioned Sergeant Lund about the me being fired from the library by the trustees.
If the investigator questioned the police officer?
Yeah.
Okay, this isn't, we're not asking questions of the investigator at this time. This is your time to present your side of the case to the commissioners. If there's anything you'd like to say.
It's kind of confusing because Sergeant Lund came to my house a few days after.
Mr. Goodwin, you may not have been on, you may not have been on the meeting when I said this at the beginning. If an individual is not a party to the case, so if the individual you're speaking, the police officer, is not somebody you filed your complaint against, You may not use his name. You can call him sergeant or you can call him police officer, but please don't use his name.
Oh, all right. So the sergeant told me that Mr. Beckett was gonna fire me verbatim. He came to my house and told me, and that was a few days after the incident, so I just, I didn't read no police report. It was told to me right from the sergeant.
All right, and the investigator is telling me that two things. The information about his termination was provided after the close of evidence, but the conversation with the sergeant is not in the record.
I request to have a sergeant interviewed for a statement.
At this time, the investigation of your case is complete, Mr. Goodwin, and the report has been issued.
Yeah.
Is there anything else you'd like to add?
I really don't know how to question or answer anything going on here because it's all confusing.
Okay, we'll ask the commissioners if they have any questions for you at this time then. Any commissioner questions for Mr. Goodwin? Commissioner O'Brien.
If it's in the record, are you still employed at the library?
Hang on a second. Alex, is that in the record? No.
Okay.
Okay.
No, mine.
Sorry, Mr. Goodwin, that's not in the record, so we can't discuss it at this time.
All right.
Commissioner Douglas.
Yeah, good morning, sir. I'm just wondering, when the assailant there went out on leave, Mr. Becker, was that communicated to you that he was going to be out on leave? I mean, I'm assuming
I requested.
Go ahead.
I requested to the other trustees to have him removed if I was going to come back, and they refused to do it. And then things started going sour after that. Just nothing was good.
I'm just wondering if, and you said you wanted him removed, at some point somebody told you he was on leave, right?
Yeah, but I didn't know if that was just temporary because of what happened or time-wise. It didn't sound like he was fired or removed from the board. It was just like a vacation until things get better.
Okay, so what you're saying is you didn't know if he was coming back or not?
I didn't.
All right, thank you.
And the other trust, yep.
Yep, thank you.
Yeah, thank you.
Any other commissioner questions for Mr. Goodwin? None. Attorney Williamson, you have about 5 minutes left. If there's anything else you'd like to add.
Do not think that I have anything additional to add. Thank you.
Any further questions for Attorney Williamson? Seeing none. And Mr. Goodwin, you have about 7 minutes left. If there's anything else you'd like to add, you don't have to at this time.
I think I'm all set right now. Thank you.
Thanks. So we've heard from the parties. We'll next hear from Investigator Brindley.
Good morning, commissioners, Barbara, Kit. So I think here there's no argument over whether the respondent in question engaged in this inappropriate sexual conduct. The question here seems to be whether or not the complainant overheard the statement to the police or learned of it afterwards. I don't think it really changes my analysis at all. because regardless of whether this happened, the statement was made. Conduct was severe, subjectively and objectively offensive. And as I believe Commissioner David said, he has authority. He has super authority. Whether or not he had direct authority over complainant as a supervisor or a manager, he did hold a place of authority in the library where complainant worked. So I believe complainant reasonably believed that the respondent had authority over his employment in this case. And even if he didn't have a supervisory role over complainant individually, the conduct itself created a hostile work environment which negatively interfered with his employment. Any questions?
Commissioner O'Brien.
Hi, Alex. If that statement were not part of this at all, if it wasn't made, it wasn't alleged to be made, do you think, would your assessment be the same?
Yes.
All right, thank you.
Commissioner Douglas.
Yeah, good morning. So I'm just wondering about, because I understand what you're saying. I'm just wondering about the business where he's on leave almost immediately after this occurs, right? He's on leave as of August 24th or whatever the date is. He's on leave until after the criminal thing concludes, at which point he's terminated. And so what did your investigation reveal in terms of what was conveyed to the complainant about that leave, if anything? I asked him that same question and it seemed like he didn't really know what was going to happen.
And as Mr. Goodwin stated in his statement, he wasn't really told the reason why the respondent was placed on leave. I believe he was just told he was placed on leave pending the investigation. So I don't know if the complainant in this matter was given like a timeline when he would return, if he would return at all. But I think it's exactly that, because he didn't have this knowledge that the respondent would return, that, you know, continues this interference with his employment.
Right. And just to follow up on that, was anything conveyed in terms of your investigation, was anything conveyed to the complainant in terms of what authority this man had while he was out on leave? Whether he's still serving in some sort of reduced capacity as trustee or whatever. I think we all have an understanding of what on leave means, but I'm wondering what was conveyed to the complainant.
I'm not exactly sure what was conveyed to the complainant in this matter, but I do know that the respondent did not engage in anything with the library when he was on leave.
Okay, and as far as your investigation shows, the respondent did not engage with the complainant either once he was on leave. Is that fair? Yeah, I think your audio is gone. Can you repeat that?
I said yes, that's correct.
All right. I was trying to lip read.
You cut out for a minute, Alex.
Yeah. All right, Alex, thank you.
Commissioner David.
Yeah, Alex, I certainly agree that the conduct is severe and unwanted. I have no problem at all that since he's a trustee of the library and he knows it and the complainant knows it, that out of work assault creates a hostile work environment when he continues to be a trustee and complainant continues to be employed. My concern is, am I correct that your recommendation is for no finding against the library because of their immediate response?
Yes, I think that's accurate.
So what are the consequences to the library of? Are there any? They're just totally not responsible?
Well, we didn't receive a submission of disagreement in that case, but I believe your assessment is accurate. In my finding, I found that the library acted promptly and appropriately when it placed Mr. Beckert on leave.
And I'm seeing the footnote 3 that cites the main support, the case saying that the employer is not vicariously liable under our act if the conduct is not performing work or under the employer's control, which seems correct on its face. But I'm still troubled by the fact that the reason that the case is here at all is because he's a trustee, right? Otherwise, it's just a criminal case of an assault or a civil case for damages for assault. Seems as though we're letting the library legally has no consequences. But I have my question for Barbara, sort of. What procedurally happens if we were to find reasonable grounds of, if we were to follow the recommendation and find no reasonable grounds ×2 for the library and find reasonable grounds for Beckett? Is he the only one that is invited to the conciliation and the resolution?
Yes.
And is he dealt with on a personal basis in terms of a settlement discussion about money and that kind of thing?
He is, because interference is, well, I mean, an entity can be held liable for interference as well, but in this case, it's individual liability. And the way we do interference is there has to be some individual act of discrimination outside the bounds of the employment that the individual accused of interference has committed, in this case, sexual assault. The library was not found liable because they established their affirmative defense, which is that they acted promptly and appropriately to make sure this didn't happen again, and it didn't happen again.
And we're at the case, totally hypothetically, that the libraries had some knowledge, there'd been prior history or something like that, then we'd be still considering whether they had a responsibility.
Could well have been a different outcome, absolutely.
Yeah. Okay, thank you. Thank you.
Any other questions for Investigator Britney? Seeing none, thank you, Alex. We've heard from the parties and the investigator. At this time, we are looking for a motion. There are 3 proposed findings.
I move to adopt the investigators' recommendations as they appear in the report.
Second. Okay. Moved and seconded. I appreciate that efficient motion. Any discussion?
Yeah, I think the reasonable grounds finding against Mr. Beckert is tricky. I understand, what the argument is. I think the only thing that gets me there is the even chance standard, really. I mean, it seems like there are some pretty significant factual findings and factual disputes that are sort of right on the line. So I just wanted to put that out there.
Can you say more about that?
Yeah, so I mean, okay, so there's the issue I'm having, right? And maybe I'm completely off base, but the issue I'm having is this conduct occurred offsite, right? It occurred at a restaurant. And now we're sort of tying it back to the workplace where the conduct creates a hostile work environment, right? And so the question is, what's the, you know what I mean? How do we tie it back? How does it create a hostile work environment? There's mention in the report about a statement, right? That the complainant supposedly overheard, but then respondent says, no, he wasn't there, he didn't hear it. Then it's in the police report. There's no telling when the police report was issued, and maybe complainant read that report and maybe he didn't, right? I mean, who knows? So then the question is, was he just sort of in fear because this guy's a trustee and he engaged in this conduct outside of work? And I think that's the most plausible thing, right?
Right. I think even without the statement, that's exactly right. He goes back to work and the trustee assaulted him.
Right, but he's on leave. And so that's why all these questions about what does that mean and what does complainant think it means when he's out on leave?
He's on leave because he assaulted him.
No, I understand that, but I mean, what is complainant still believe this guy can mess around with his employment, I think is the question, right? Is he gonna come back? Is he gonna assault him again? Is he gonna get him fired? So, you know, I mean, I find all that to be a little.
Yeah.
I'm going with motion.
I hear it.
Commissioner,
I
I'm just
hear you.
expressing
No,
that I find this to be a little.
Yep.
Not as clear as it may seem, that's all.
Any further discussion?
Generate more if you like.
I think you're good.
Well, I mean, I do agree that's a little bit tenuous, and I'm still concerned about agreeing that the library has no responsibility for its trustee. And I'm being asked to say that by saying there's no reasonable grounds to believe they discriminated, which sounds correct. They didn't do anything, and they found out about it when we all found out about it.
All right,
So,
but then, see, that now raises another interesting point. I'm sorry, Barbara, but that raises, because
I'll
if,
take you all out.
because the thing is, right, I mean, they find out about the conduct of the library and they put them on leave.
Yeah.
Right? What else are they supposed to do? They
Right.
put them on leave, they're removed from the workplace.
what else can they
But then
do?
if that's good enough for the library and he's out on leave, then how can we find a hostile work environment on behalf of the, you know, this interference claim?
Right.
You see what I mean? It all becomes a little, these findings are not necessarily consistent, I think.
Well,
So,
they would say, they would hypothetically, they would say, well, we couldn't fire him because he hasn't been proven, you know, he's not guilty.
Well, they didn't have authority to fire him.
Yeah.
Only the probate court could remove him
Right.
from that trustee role.
right, and the investigator told us there was no communication between these two after he was placed on leave. He was not in communication with the library, he was not in communication with the complainant.
But doesn't the no communication with the library though generate the sort of factual circumstances for a complainant to fear, right, that perhaps respondent could interfere with his employment, notwithstanding the fact that he's on leave?
Right.
No,
Yeah.
but we could go round and round all day.
Okay.
I don't understand what you just said, but it's fine. Yeah.
I think it's gonna depend on
But
the
then
facts
I'm
that have to
gonna-
be presented. That are gonna
I
be
think-
different or more than what we've heard.
Going back to my first comment, I think the even chance standard is the thing that gets me there, but I think it's, you know, I think it's there, it's interesting when you think it all through. I think the proposed finding in this case is very interesting. So still gonna vote for it.
I'm offering Barbara's services. I wonder, Barbara, would it be helpful to spend a little bit of time talking about the sort of concept of agents like, you know, a sort of supervisor, supervisee entity, agent liability when it comes to criminal conduct of the agent?
I mean, it might be helpful, but somebody who knows criminal law is gonna have to talk about it.
From an employment context, right? So the question is the sexual assault independent criminal conduct, right? Is that within the scope of what the entity is responsible for? And, right, correct me if I'm wrong, Barbara, courts hold, generally speaking, that an intervening criminal act, the entity, the employer in this case, right, the library, although not the employer, is the entity, he's the trustee, is not responsible for that criminal conduct.
Yeah, which is why yes, but also which is why the footnote to that recent law court case where it's a case where somebody working at a drive-through left their position, went outside and screamed horrible things at a customer. And the law court found that the restaurant was not liable, again, because that was not in service to the employer and was outside the scope. So I think that is why the library is not responsible here for off-site misconduct, to use a
But that
too nice word.
Criminal.
that off-site misconduct can certainly affect his employment.
Sure.
And it's, that's, yeah,
Absolutely, and that's why the findings against
Right.
him individually,
Right.
because.
And that's
he
how I get
remained-
there for that.
Yeah. Can scowl at me all you.
Not scowling at you, Barbara.
The question of liability, though, of course, right, for the library could change to your question, right? For example, had the library been aware
Right.
of previous conduct of the same kind,
Right.
right, would have been on notice.
Right.
There was a propensity for that, perhaps.
Let's do it.
Seeing no further discussion.
I have more to say.
If you are in favor of, the motion is to find no reasonable grounds against the library, reasonable grounds against Mr. Beckert. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Right.
I want you to note the hesitation for.
Yeah. That will not be in the minutes.
It really-
Findings are no reasonable grounds against the library, reasonable grounds against Mr. Beckert. We thank everybody for their participation, and we will send the parties a letter confirming the results of the hearing.
Call that dramatic pause.
That's right.
Yes.
That's dramatic. The next case is E 22-0220, Marianne Warner versus True Value, and that's the case that you indicated she asked to withdraw. Is that the correct, is that what she asked?
She sent an email to me stating, I would like to withdraw my complaint at about 7:10 last night.
And we rejected that, and therefore the case is still before us, is
It
it
is still
not?
before us, yes. I am not sure, there's somebody here named Mary Green. I'm not sure if that's Ms. Warner. Ms. Warner, are you with us?
She's one of the people in my case. She's from the Self-Harm Housing Authority.
Mary Green, okay.
I could have been Mary Green.
No,
Seems
she was the only
unlikely.
person who had a name that seemed close. Anybody here?
Her and Nana are from this position.
Okay. Is anybody here for Marianne Warner? Once. Okay. Chelsea, will you just poke your head out and make sure there's nobody waiting room? Okay. So in cases where the party who submitted a disagreement is not present, we generally adopt the investigator's findings. The investigator in this case was Colin, again, so if you have any questions for Colin before you vote, it's right here, okay.
I'm disappointed that she's not pursuing this because I wanted to hear the presentations. As I understand it, do we have the number, the dollar value of the loss of the client when the client withdrew their most of their business relationships with True Value? And then, as I understand it, and it's then thereafter, if they're left with 10% of that relationship, then True Value says, we're not gonna bother with you anymore, we terminate you, therefore, there's no commission being paid. I mean, it just seems to me that that's a triumph of form over substance, and that she's being discriminated against, if there are numbers there.
So you're referring to the complainant's client who withdrew from respondents? Is that what you're
Yes,
asking about the
business
number?
relationship. In other words, that's the basis for deciding whether or not a commission is paid or not.
I think so I believe the numbers are there. I don't
Are they?
know there off the top of my head, but I did get some spreadsheets and whatnot from the two parties.
Well, I found it confusing to try to read the the written response and that chart, and I couldn't, that's why I wanted to.
I think the primary dispute here is about, so the respondent's submissions explained that, and their policy at that time was that there's sort of two ways to approach the loss of a client, or the loss of a store. One way, and this is because of COVID. This came about during COVID and because of logistical issues. So one way is that if the compliance client store, whatnot, voluntarily withdrew, said, I'm going with somebody else, then that's counted as a loss against complainant. But in the case of the other individual, it was the respondent who made the decision to cut ties, not the store. So in situations where the respondent, because they're basically saying, we don't have the ability to keep up with supplying you anymore because of COVID and logistical issues, we're not going to count us cutting off that relationship against the salesperson in that case. But if you lose the store, we are going to count that against.
And they're saying here that she lost the store because they terminated most of their relationship, but not all. And that's why I'm saying, how don't we need to know how much of the relationship they terminated?
They ended up cutting all ties. So it's initially.
Well, am I wrong? Then that's my question. I thought they terminated most of it, but not all of it. And if they terminated most of it, she'd be charged with losing the client, losing her commission. But they're saying that they responded, terminated the relationship.
So if I remember correctly, what happened is that you're correct that initially they basically made the respondent their secondary supplier at some point. I don't remember the date.
Right. Yeah.
But I think later on withdrew completely. So the relationship was completely severed at one point, if I remember correctly. By the store withdrawal. By the store, yes.
And therefore she's charged with losing the client.
Right, that was kind of.
Okay, then I misunderstood.
Yeah, it's convoluted, definitely.
Well, yeah, it is, and that terminology, what is that?
I had to read through it several times.
Yeah, if it helps, those facts are laid out at the bottom of page 2, starting in the last paragraph, and it reflects that, in fact, it was the store that terminated the relationship, not the respondent.
Okay, thank you.
Any other questions for Colin? Attorney Wissa, we do see that you're here because complainant wasn't here. We don't need a presentation from you, so we appreciate you being here. This time, if there are no further questions for the investigator, or I guess if there are no questions for Attorney Wissa, we will entertain a motion. There are 2 proposed findings. Commissioner O'Brien.
I would take them together. There are no reasonable grounds to believe that True Value discriminated against Marianne Warner on the basis of age, and that there are no reasonable grounds to believe that True Value discriminated against Marianne Warner on the basis of sex, and the complaint should be dismissed.
Second. Right, it's been moved and seconded. Any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
So the findings are no reasonable grounds. Thank you, Attorney Wissa, for being here, and we will send a letter to the parties confirming the results of the hearing.
And the next case, is it our last case?
No, 2 more.
Is E22-257 Cutliff versus 5 County Credit Union. The recommendation is for finding of no reasonable grounds, and therefore we would hear from the complainant.
Ms. Cutliff. And sorry, we need your name.
Yes, my name is, good morning, Commissioners. My name is Richard Cutler. I'm Jordan's dad. She's the complainant in this, so she had emailed and asked if I could speak on her behalf, and she was told I could.
Okay, great. You commit, did you want to save any of your time?
I want to save as much as possible. I got a lot to figure out, so I would say at least 3 minutes. If I can do 5, that'd be great.
All right, we'll start you off with 7. Go ahead whenever
Okay.
you're ready.
So the reason for the rebuttal is due to facts in the investigator's report that were omitted and statements that were made that don't appear to be factual. So I'm going to take you through a little bit of a time frame here. One of the reasons why I think some stuff's omitted is I don't think that the investigator listened to or viewed the resolution conference, and I'll get to why I think that. So Jordan's case was assigned to an investigator in September of 2023 who no longer works here. He had the case for 5 months before Jordan was told that her case was being reassigned by the lead investigator. During the resolution conference, the investigator had mentioned that he was going to provide a link for the transcripts and for the recording for the case. No link or transcript was ever sent. On February 21st of 2024, the lead investigator notified Jordan that the initial investigator was no longer employed and that they'd be assigned to a new investigator. So this first investigator had the case for 5 months and no report was completed. Jordan never heard from the second investigator until she got a report on April 26th that the investigator Morse's report was complete. Read the report. She submitted a rebuttal in May of this year, May 13th to be exact. And a lot of the rebuttal statements were in reference to evidence that was not in the report regarding statements made in the conference. 4 days later, May 17th, Investigator Morse sent a link of the transcript and recording conference to Jordan, but it wasn't her conference, it was the conference of the second case you heard today. So, of course, after viewing the transcript, she realized that's not my case, this is somebody else's case. So that leaves me, and then of course that I think Investigator Morse realized that she sent the wrong stuff and sent Jordan a statement, an email saying, disregard this email. And in the email it says, does not appear that the former investigator assigned generated a transcript for this matter. So to this date, Jordan never received a copy of the transcript. However, she was smart enough to do at least a recording of the conference on her own stuff. So that kind of just leads me to think that if Investigator Morse had reviewed the transcripts, the audio, she would have never sent the wrong one because she would have known that. I mean, that's all right. So some of the things that were not reported during the conference at approximately 19 minutes and 11 seconds, they were asked if Jordan's issues, her work issues, were related to her disability. The respondent's attorney testified, we understand that her issues were related possibly to her autism. That doesn't mean we could have done anything about it. Same conference at approximately 50 minutes and 53 seconds, the respondent's client, I don't know if I can say her name or not. No, the manager, Jordan's manager, was asked if she thought Jordan's disability was due to a disability. And Ms. Merrill replied, I think I can't answer that it was due to a disability. It was that she did not like working with people. It was the face-to-face with members. So I think that's relevant, that there is a conflicting statement that one party in the respondent's party says, yeah, we understood that her issues were due to her autism. And then the manager says, no, I don't think it was. I look at the manager's response, and it seems like it is a judgment of character instead of understanding that some people with autism have issues with dealing with people. So, and I just don't understand how they're in the same party, they could have such conflicting statements. Okay. In the report, it was reported as fact that the manager spent a considerable amount of time mentoring Jordan, and she received extra coaching and supervision. This is a fact. I don't see where there was any evidence to this. There was one document submitted by the manager labeled Exhibit F from the respondent's paperwork. This one statement points out one incident. We talked about the incident during the resolution conference. It was an incident that occurred in June with a difficult member. During this incident, the manager points out that Jordan did everything correct, but she had an anxiety attack. So and she went to the manager for assistance. So in this document too, she tells Jordan what she did wrong. She tells Jordan what she did right. And then, so I'm reading this of this considerable amount of mentoring, and her follow-up after the incident was take the weekend to really think about if or how you'll manage things in the future. I mean, this.
So that was your 7 minutes. Do you want to keep going? You have 3 minutes left total.
There's so much. There's just so much in the conference that wasn't added to the report. Let me go for at least another minute or two.
I mean, it's at the timer for 3 minutes.
Oh, you do? You have it. So I have 3 minutes now, or
You have 3 minutes now, and at the end of 3 minutes, that will be your time.
okay. I'll stop now.
Questions for Mr. Cutlass?
First of all, I just want to acknowledge the fact you're here advocating on behalf of your daughter. I think we all appreciate that. Everybody that's sitting here understands how difficult that is to do, to present to 5 people on issues like this. So I just want to say that I appreciate what you're doing. I guess I'm just curious, looking at the record here, looking at the job descriptions and all these sorts of things, just to sort of cut right to the chase. And with respect to reasonable accommodation, you read the report, the investigator found that, your daughter didn't request one. But I'm just curious, what sort of accommodation do you think would have been necessary or helpful for her to deal with the public facing aspect of her job?
Sure. I think that, one of the ideas is, if you have a new teller, especially if you have somebody who's autism, you've probably seen it in other businesses where, new employee, please be patient, something like that, where she could have had a sign. There could have been extra training, like maybe after hours. I don't know if the manager, if that would be a hardship, if she was on salary, or they would have to pay her overtime. I don't know, but there's so many times in the whole report about, well, we don't know if we could have done anything. All right, yes, Jordan didn't ask for an accommodation, not because she didn't want one. She didn't know about it. I didn't know about it, honestly. And I have two autistic kids. Now I do. I'm very well educated now. But and again, I don't want to minimize what the manager and the staff at the bank had to go through. I raised her, so I know that there can be difficult issues and there can be time. And me and my wife, we've pulled our hair out at moments trying to figure out how to help her. But it's effort, and of course we're her parents, so we're going to do that. And I don't expect the manager of the bank to do that. But I don't really see where there was a considerable amount of mentoring or training. It's almost it, and I don't think it was on purpose. I don't think she's an evil person. I just think she just didn't know how to navigate it, and that's I guess that's okay. But just because Jordan didn't ask, you know, the ADA it's another committee, I can look at it. But what I read about was just because a person doesn't ask doesn't mean you can't ask them if they need something. And Jordan emailed her diagnosis to Human Rights, and they responded back, what kind of accommodations do you need? But she never answered because she didn't know what that meant. And she didn't come to us with it, you know, so I couldn't help her until it was too late. But I think if she had known what that meant, she might have answered. But so and
the answer would have been, just to sort of focus you a little bit, the answer would have been something along the lines of maybe a sign,
right,
additional training, et cetera, et cetera.
Be a little bit more patient.
Things
We
along these lines.
need repetitions, and the sad thing is, which I know her so well, is she could have been one of those, and she's been given the time to succeed because she would have been that employee that not looking to leapfrog, not looking, it's just stepping stones. She would have been a 20-year dedicated employee. She never missed any time. She never had any attitude problems at work. It's just one of those things. It's a sad situation, but we've also taught her that it's important as she goes through life. You have to advocate for yourself. And this has been tough on her, and it's been tough on us. And we understand that business is business, but the reality of it is I think there was never an intent to do a settlement for money. It's never about money. It's about change. It's about education for the systems, for the people who have to deal with, you know, like Jordan come along. So
thank you.
Yeah.
Sure, David.
What do you make of the claim that they, I assume, will say or that appears to be the case, that she's in the wrong job? She's in a public facing job that does not allow, well, in which her disability prevents her from doing that.
Well, I would say historically it may appear that way because we have one incident really that's documented in this whole case. I wish there would have been more. I mean, it's really nothing in a personnel file. But knowing her and seeing her, she used to work at TJ Maxx. She worked at cash register. She worked the floor. She currently works at Hannaford. She works in a bakery.
Mr. Cutler, I just want to.
I'm sorry.
We can only talk about what's in the record. So if her current employment is not in the record, we can't talk about that or her past
He
employment.
was asking me to.
I understand,
Okay.
but his questions are limited to what's in the record.
Sorry about that. Sorry. Can you repeat the question, please?
No, I think I got it. Well, what you just said was that there's only the one incident in the record.
Well, there's also a lack of a witness testimony that she saw Jordan improving. She saw her doing the things that the manager claims that she wasn't doing well, and that was submitted in the original paperwork and the response. So that's not new information.
And you're saying that submitted in the record, but it's not.
It was never
not recognized
right.
in the investigation
and she
report.
wasn't
Relevant.
Yeah, and she wasn't available, I guess, for the conference. So they brought in their own other employee as a witness, which kind of gave the same testimony that Jordan did during this difficult member incident. He said, "Hey, if things get too difficult, I back up and go get help." So,
is it in your view? Is it relevant that she's still on probation in the employment?
No, I mean, I think that the manager wanting to see her succeed and have, succeed maybe with a difficult member, although you can't, how do you know when that next difficult member is gonna come in, right? So you have one incident, she has an anxiety attack, which was characterized as a meltdown in the respondent's paperwork, but it's kind of insensitive, but because I wasn't there, because I never spoke with the manager really, so I'm just going by with what was said in the conference. It was a lot of, well, we don't know what we could have done. Oh, she never asked. It almost feels like if we ignore it and she doesn't do a good job, then we're going to use, policy saying she's not able to do the job, so we're going to terminate her.
In your response, you said that the handbook, I want to ask you about the handbook issue and whether they followed their own procedures in terms of progressive discipline. You said that the handbook that was submitted was after a new one that was not the one that was in effect?
Right. So she was issued a handbook initially when she was hired. It was consent by a human resources steward. And then she had a paper copy. We matched those two to make sure that they were the same. But the pieces that were sent to the commission were updated policies. The attorney stated that Jordan was aware, or should have been aware, because she signed the original policy that when updates are made, it's her responsibility to make sure that they're there. I didn't see them present any evidence that they emailed copies of like, hey, this policy's updated, this policy's updated. There's nothing.
What's the substantive difference?
What's the difference?
Between the update and the
If it's in the record.
It is.
Well, if they're both in the record, are they?
Okay.
Yeah.
Okay, so what's your argument that there's a substantive difference?
The difference is that the updated policies keep the manager from looking like she violated policy. So like they're going to terminate Jordan on a policy issue because she's unable to complete the standards of her employment. Yet, for example, people in their probationary period are not supposed to work overtime. The manager issued her overtime. We submitted a document that shows a pay stub that has overtime. The disciplinary procedure is supposed to be a progressive disciplinary procedure where you speak to a person, maybe you write something down, put it in their personnel file. They're claiming that they don't have to use that progressive discipline when they're on probation. So it's almost like, well, the policies apply to her, but only some when she's on probationary period. It's like,
well, that seems to me to be significant. You're saying that they're saying, and we certainly will ask them, that they're saying they don't have to follow the progressive discipline because she's on probation.
That's what they're saying.
Okay, yeah. Thank you.
So you'll have 3 minutes when we come back to you. I believe Attorney Connolly is here for the respondent. Yep.
Yes, I am here.
Great.
Is my mute off? I guess you can't answer that unless it is, right?
We can hear you.
Okay.
Great, and now we can see you. So you have 10 minutes. Do you want to reserve any of your time?
I'll reserve 4 minutes. And I'll just be brief. There's nothing really new that was discussed today. This is the first I've heard from either of Jordan's parents. She represented herself at the conference, and she did an excellent job. She's a very nice young woman. We have submitted a very detailed position statement, which was verified by 2 different people. And then we also submitted an affidavit signed by a person who interviewed her for the position. And from the beginning, she said she wanted to basically go out on a limb a bit. This is not her comfort zone to deal with people face to face, but she wanted to give it a shot. And initially, because it was in the middle of COVID, she didn't really have to deal face to face. She had some issues. It wasn't perfect, with the drive-through people because they're doing everything through the drive-through window. But that was easier for her, and because there was another employee who usually a friend of hers that she liked very much right next to her. They could work together because no one had to work the front. It was closed. But she knew all along this was temporary, and then this was a branch that's going to get going. It's not a big branch, but they were going to have a new branch manager. New branch manager came in and worked with her for months. They extended the introductory period and tried to work with her to see. And as they changed over to having the three tellers, one of them every day had to work the front desk, and she did not like it. She did not perform well. Again, in the verified commission statement, there's several examples of her job performance not being up to snuff, and her not liking and really almost fearful of dealing with the customers face to face. The investigator got it right. It was a fairly detailed report. There was nothing that was missing. I don't know if I don't remember it was recorded or not. I think Jordan's parents were there taking some notes. We took notes. I don't think it was recorded. There was no really conflicting statements. First of all, I was the attorney. Wasn't testifying, but what the manager stated was she knew she had autism. She had dealt for many times with years. She had experience dealing with people with autism, but she didn't know if all Jordan's issues were directly related to the autism. She didn't know that one way or the other, but she was evaluating her as she would any new employee, and she simply wasn't able to do the job. She had other issues too that had nothing to do with face-to-face, but that was one of the principal reasons she couldn't do it. I thought the handbook was a dead issue. I saw that raised again. As in most handbooks, it clearly states that these evolve and it can be changed at any time by the employer, and this one was. So when the commission asked, they don't want the whole handbook, so I didn't submit the whole handbook. They wanted certain sections. I submitted those sections, and the page numbers were different. I don't think there was anything really substantive change, but apparently the argument was made by the complainant that this was some kind of conspiracy, that I was deliberately sending the wrong handbook. We were sending the handbook that was in effect when her job was terminated, not when she initially started. Although, again, I don't know if there's any substantive difference. I don't have the two in front of me. I thought that was long ago a dead issue. The key here is she never asked for an accommodation. We did the best we could. And then even during all the hearing, even today, still we haven't heard what that accommodation could be. They give her more time. She had more than just the introductory period. They extended it for months. And she also had the advantage of starting slow because of the COVID. So they had many, many months to look at her. She's a very nice girl. They liked her. The manager liked her, worked hard with her, tried to make this work out, and it's the wrong job for her. I mean, that's what it seemed to be. And someone look at my notes quickly just to compare. Again, he's Mr. Cutliff, who has done a nice job representing his daughter, and but lets the commissioners know that this is difficult for them even, and they've obviously had her whole life. And he said that he didn't think that he wanted the manager wanted her to succeed. We testified to that, and we did. It just it didn't work out. And when Mrs. Cutliff came in, she said to them, and this is in the record, that we were told it wasn't member facing, and we're like, no, it was member facing. And sorry if you didn't understand that. I think it was clear that it was. We submitted the job description. It talks about that, the importance of that, it being a member facing position. And now they're trying to dispute that, but they could have submitted an affidavit. Mrs. Cutliff, I guess, could have come testified as well, but nothing was submitted to counter the verified position statement from the respondent. That is exactly what was said. So
that's your 6 minutes, Attorney
thank
Connolly.
you. I will hold off and for now and take my 4 minutes and if I need them. Thank you.
Questions for Attorney Connolly? Commissioner David.
Attorney Connolly, you said a couple of times that they bent over backwards because they extended her introductory period. Are you saying that they said she continues to be on probation, and is it your argument that that gives them a greater authority to terminate without reason?
Not without reason. And they refer to it as an introductory period. Obviously, a lot of businesses refer to it as a probationary period, but they treated her as they would have anyway, in terms of evaluating her performance and coming to the conclusion that she could not do the job with any accommodation. They couldn't think of one, and she didn't ask for any. So it really didn't, in the long run, it really didn't matter that she's still in the introductory period, but she was.
You're saying they couldn't think of any accommodation and that they were thinking about it, but they're not talking with her about it. It has to be an interactive process, does it not?
It was ongoing interactive process between her and the manager, trying to work with her. Okay. And what she did, and this was actually seen apparently by the complainant as a criticism, is that the manager gave her a couple extra shifts at the front desk to watch her more carefully, give her more opportunities. And it wasn't working out. At one point, it's in the report, she left and hid in the bathroom for a bit. She just did not like dealing face to face and wasn't able to do it. And it would get worse if obviously the most important part of dealing face to face with the customers is if they have an issue. And she really would have trouble, even at the windows when they drive through. She had a difficult time handling any person who had a true issue or any type of complaint.
I'm hearing you say that they did engage in an interactive process, but they didn't call it that, and they didn't document it in a personnel file. Is that correct? That it's not documented?
In her personnel file, there is notes as far as what the manager did to try to assist. That's in the personnel file. Whether they
okay, what did it say?
I don't. I have to grab that. I don't have that right now.
All right, that's not fair. Be the investigator. Thank you.
Any further questions for Attorney Connolly? Seeing none, you'll have 4 minutes when we come back to you. Mr. Cutliff, you have 3 minutes left.
So just go to what the attorney said. This kind of falls into exactly what I was saying before. Let's mentor by, you've heard the term insanity, doing the same thing over and over, expecting a different result. Oh, let's just throw her more shifts in front and see how she does. It's like throwing her into the deep end and seeing if she can sink or swim. I don't think it was like medievally intended like that, but that's kind of how it's viewed. No trouble with that. I don't understand where evidence is shown that she had trouble at the drive-through window. Again, she had a coworker that was mentioned in the response paperwork that was never interviewed. I don't know why. Maybe she didn't want to. Maybe she wasn't available. I don't know. And the reason you can't tell you about the notes in the personnel file, because there are no notes. Jordan requested her personnel file after she was terminated. There was no, other than when she had her first week of, or first 3 weeks of orientation, there were notes about that. But as far as notes from the manager, there were none. There were no evaluations, good or bad. There was nothing. Regarding her mother was a teller for over 10 years. there's no way that her mother would tell or would tell somebody. I mean, he's saying it's in the record. Yeah, it's in the report. Investigator Morse reported that that's what was said. But unless there was a secret recording of this conversation that that Jordan didn't have access to, and Jordan's mother did a signed sworn statement that was submitted with the paperwork in the response. So there was a record. The attorney has access to all that stuff. It was even referred to on page 12 as attachment I. So I don't know. Again, if the attorney didn't listen to the conference, didn't have access to that, I can't explain why. So speaking of the conversation that he alludes to with my wife and the managers, at approximately 25 minutes and 48 seconds of the conference, the attorney testified that the complainant's mother told the two managers the complainant was not supposed to be in a public-facing position. The respondent then stated, not sure if they heard it incorrectly or in error, which I took to mean not sure if the two managers heard it incorrectly from my wife or not, because my wife never said that. There was a statement. So other things not in the report. The respondent brings a witness that never even worked with Jordan, but in their rebuttal to our rebuttal, he said we're trying to enter new evidence. Well, they brought.
Any further questions for Mr. Cummings? None. Thank you very much. Attorney, yeah, you're on.
Thank you.
Attorney Connolly, you have 4 minutes if there's anything else you'd like to add.
Just briefly, I don't want to take up too much of the commissioner's time. Obviously, the way it works, we are asked to submit certain things, specifically not the entire personnel file. We did submit several notes written that were in the personnel file. They're part of Exhibit F that was submitted. As far as the hearing, we were told who to bring and who we didn't need to bring, and we brought people to testify about the position. They were asked to bring someone who worked there after the fact, so we brought that person too. That person may not have overlapped with Jordan, but we brought the personnel that we were asked to bring to the hearing. And again, the complainant could have done the same, brought who they wanted, depending on what the needs of the investigator were and who they wanted to hear from. But this is a situation fairly well documented that she had a lot of difficulties on the job. It's spelled out in detail, and she wasn't able to do it. And it's unfortunate, but this was a situation where to allow her to a special position when you only had 3 staff members would have been an undue hardship for this branch, the credit union. And one other thing is that, which is spelled out, is that these 3 staff members, sometimes referred to as tellers, other times as not, have to go to other branches and fill in. And then they're going to be tellers, and it's going to be 100% of that day is going to be member facing. And the evaluation was that she was unable to do that. And again, there's no thought that any way to get her around her inability, and really she seemed to really not like having to do that, which was spelled out in the job description and made clear to her in her job interview and throughout her time at the credit union. Thank you.
Commissioner David.
Attorney Connolly, everybody's bending over backwards to say that she's a pleasant young woman. There's no allegation of insubordination. There's no allegation of untoward behavior on the job. I find myself asking, why is she terminated if not because of her disability?
She's terminated because she wasn't able to do the job. She wasn't able to fulfill the job functions.
Because of her disability.
It could be, but it may not be. It could have been for other reasons as well. But she made it clear that she had autism. She did let it be known that she was going to try to work outside her comfort zone and sort of a new position. And so they hired her. They worked with her. They did the best they could, and she was not able to do the job. She wasn't asked. If there was a specific accommodation asked for, and maybe that was coupled with some information from a doctor or someone she was worked with, and they could work, but that was never done. And as far as they could determine, the best they could, and this manager with not with just with experience with a lot of different talents, but also experience working with people with autism, there was no reasonable accommodation that could be worked out at this branch that she could do the job. She was unable to do the job.
Thank you.
Any further questions for Attorney Conley? Seeing none, we've heard from the parties, and next we'll hear from Investigator Morse.
Hi there. My name is Angela Morse. So just I wanted to clarify a few things. The first is there has been the suggestion from the complainant a few times in writing during this process that somehow the former investigator, his departure from our office was related to this case, and that was not true. Second, the complainant was provided with the audio recording in this matter. That happened on May 17th, as well as Respondents Council. Let's see. There was the training log submitted by the respondent in this matter. And those do reference the complainant shutting down when dealing with customers. There was also some notes of several other incidents starting from June 15th. And also the branch manager did participate in the conference, which I absolutely watched. So I'm happy to answer any questions.
Questions for Investigator Morse? Commissioner Douglas.
Yeah, I just wanted to get your take on, I'll term it a factual dispute about whether or not there was sort of additional mentorship and training and so on provided to complainant in order to sort of give her a chance to be successful.
Yeah, from the testimony during the Issues and Resolution Conference, I do think that there was that case. It does not, nobody's disputing that the complainant was, she was a likable person. People wanted her to succeed, and that I do think that extra support was provided, and that there was the extended time for complainant to try to meet the benchmarks that she needed to, continue on in that role. But, frankly, it just, for me, it came down to the fact that the complainant couldn't perform the essential functions of the job, and she never requested any sort of accommodation.
All right, thank you.
Commissioner David.
Angela, did they follow their own progressive discipline policy?
Well, there was no discipline, but it was documented, the complainant's deficiencies in this role. And, she was in the probationary period. So I think she was given the opportunity to succeed in that role. And she was spoken to also when her work product wasn't meeting what was needed for the position. So not disciplined, but she was counseled, and she was made aware when she wasn't meeting what she needed to do for that job.
That's in the testimony. You said it was documented.
Correct.
The complainant says there's nothing else in the personnel file.
Well, I'm looking at, I was just looking at it a second ago. So that was, there's training notes from June 15th. And then there's also notes about the scenario when she had the difficult customer and she had a difficult time working through that process with the customer. So those are
That's-
submitted in the respondent's answer, which complainant did receive. Let's see, I think it's Exhibit D here. Okay, hold on.
There's the one incident with the difficult customer,
Mm-hmm.
and then you say there are training notes. Do they say that
Yeah.
she did the job?
So the training notes is Exhibit D in the respondent's answer. It's dated March 25th of 2022. This talks about working that complainant had made the comment, "I'm so dumb," and seemed to shut down for the rest of the day. We spent the last hour of the day just discussing things we had gone over and recapped items on Compass that will be helpful in the branch. And then there's other notes as well, from June 15th, June 17th, June 18th, and then notes on the July 8th termination meeting.
I want to see that you.
Go, go,
No, go ahead. I was looking to see if I do have one other.
Angela, I must have missed it, but I'm hearing you and understand that the probationary introductory period was extended.
Correct.
I missed that. So was it set for a certain time when she came in? Was it 3 months or 6 months when she was hired and then extended? And how long was it extended? Do you know that?
Yeah, I'm not sure what the typical introductory period is, but it is mentioned by respondents that that period was extended, and she was still under probation when she was discharged. But I'm not sure the exact time frame that's customary.
Thanks.
And that's exactly my question, Julie, is, and it's a question for Barbara, and I think I've asked this before in other cases. What is the import of the probationary period? I used to tell people as a private attorney, well, if you're on probation, they don't need to give you any reason at all. But my understanding is they don't need to give any reason at all unless it's a discrimination, and that still applies, and they still can't terminate you if it's unlawful sex, race, color, all that stuff.
Don't know what the question was.
The question is, do they have to give a reason to fire a probationary employee?
I mean, ultimately, yes, because by statute in the labor laws, it says if you're asked for a reason, you have to provide one in writing. But whatever due process protections there normally are, you don't necessarily, we're not talking due process anyway, because it's not a state job, but oftentimes during the probationary period, there are different standards.
Are there different standards that are applicable here? Do they have to follow their own progressive discipline?
Complainant wasn't disciplined.
I know, that's the
No,
jarring
I'm saying
point
there's
of
a
it.
difference between conduct for which you are disciplined,
Right.
like messing up a deposit or stealing. And there's not being able to perform the essential functions of the job, which you don't get disciplined for, but for which you may lose your job.
You just get fired.
And
Sure. Okay, thank you.
Any other questions for Investigator Morris? Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed finding.
I move to adopt the investigator's recommendation report as written.
A second.
Been moved and seconded. I get a sense that there may be some discussion.
Well, there may be some difference of opinion, but I'm not sure whether we can resolve it amongst ourselves or not. I certainly am not happy with it. I think I don't think there was progressive, interactive discussion to deal with this young woman's disability. And I think it's as likely or not that that might be a finding of a fact finder.
So I think what it comes down to is whether or not she can perform the essential functions of the job, the public facing aspects of the job. And I hear what you're saying, Mr. David, and I'm sympathetic to it, but I think this is a closer case.
I think we could have tried harder.
Yeah, I agree with that. I think it's a closer case than is indicated here, but I do think it tips just ever so slightly towards the bank insofar as I haven't heard anything that convinces me that she was going to be able to perform this job the way it's currently described.
Does it relevant? Does it convince you that she's still trying? That she doesn't quit and say, I can't do this. I can't deal with these crazy people that come to the window and make demands of.
I think it's admirable.
Yeah.
I mean, one of the most compelling things about this case is that this young woman said, this is outside of my comfort zone. Right. And I'm going to try to do this anyway. You want to get behind that, right? You want to support that. I'm reading the record and I just can't see, and it pains me to say it, but I just can't see how this was going to, I mean, it seems like this was a very sparsely staffed day, right? Everybody needed branch, right? Everybody needed to sort of step up and do whatever needed to be done. Probably a fairly frenetic environment from time to time. And I think the instances where she's dealing with the public and having these difficulties, I just haven't heard anything to convince me that she was going to be able to overcome that. That's the issue here. And I think it's really unfortunate.
I think the inner struggle I'm certainly having as well is there evidence to support a finding that there are reasonable grounds? I haven't seen anything. And at the same time, could the employer have done a better job? Could they have been a better employer with respect to working with the complainant to, find out with great specificity what the need for accommodation might look like? Absolutely.
Right. I mean, they knew she had autism, right? This was something that was discussed. Right. So, yeah. Agree. Unfortunate case.
I think I agree with your analysis also. That's where I'm coming from. And I think it would have been nice had the employer stepped up to find maybe an alternative situation for you, or do the better training and longer probation with actual hands-on, help. Because it seems like there could have been a resolution.
Yeah, but it's not just that it would have been nice if they stepped up. They have an obligation to under the law.
I know, I think it would have been a different case had there been a request for an accommodation. And the only way you would have known that if you'd hire a lawyer.
Am I allowed to ask a question?
No.
I assume that was going to be.
I could just offer one more comment. It was mentioned during the complainant's presentation that this is not about money. It's not about some sort of settlement. This is about recognition, acknowledgement, change. These are my words, not necessarily your words, but these proceedings sometimes have effects beyond the result. When people have to acknowledge they've now been in front of a body like this and there have been comments made and they've had to make their case. And so I think that you folks should take that out of here with you today, that there may be effects of this proceeding beyond what the ultimate result appears is going to be.
If there's no further discussion, the motion is to find, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien?
No.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds. We thank everybody for their participation, and the commission will send a letter to the parties and their counsel confirming the results of the hearing. And I'm sorry, Ed, I need to take another 5
Sure. No,
before we do the
In order, the last case on our agenda is H 24-0031 A and B, Ryan Tinsman versus South Portland Housing. The recommendation is to find no reasonable grounds on both claims, and therefore we will hear from complainant.
Mr. Tinsman?
Yes.
Come on up.
Thank you.
You have 10 minutes. Do you want to save any of your time?
Yes, I'd like to save 7 minutes.
So we'll start you off with 3. Whenever you're ready.
It really isn't good.
Fair enough.
Stomach. So like a lot of people, there's multiple things I'd like to address on this, but I'm going to try to keep it focused to what I was my most recent responding letter to you. Basically, I presented the investigator with a list of what I thought were relevant witnesses to various pieces of all of this, and the witnesses I've talked to have not been spoken to. So that concerned me, especially when I got the result that that you guys just read off. As I wrote in my statement, I think I'm just shocked. I think there's no other way to put it. That, I actually put down that we're letting the director get away with lying because she's trying to completely exaggerate how this all started on July 8th. She said in the Zoom meeting that I followed him down and started recording him. That could not be further from the truth. I was in front of the guy, went down to move my car, and he came out talking to himself, all worked up, and I just sensed it. I sensed he was going to yell something at me or give me the finger, so I started recording as I moved my car. Well, it blew my mind that she said that in the Zoom because she knows it's a lie, and if she doesn't, that's arguably more of a concern. They also both, her and the assistant director, am I allowed to use their names since they're both here?
No, you can use Ms. Bruce's name because she's a named party, but the other person, please just refer to as a title.
Okay, so I think she's the assistant director of Leanna. Both of them at different times have stated that they told the, I don't know if I'm gonna use the guy's name.
No.
Okay, so the neighbor.
Just call them tenant or neighbor.
Okay, yeah, the neighbor that I had an issue with for months and months and months, they claimed multiple times that they told us both, they said they told us both to try to avoid each other as much as possible. Well, they've never talked to me. I think I talked to the assistant director the day before I went to court briefly about it because she called me in there to have me sign some forms that I knew I'd already signed most of. She didn't think I had. She acknowledged later in email, oh, I was wrong, you did sign most of these. So the whole thing was very suspicious. But I've never got to talk to the director about this incident at all. And what bothers me about that is that's also a bold-faced lie that's very, very, very relevant because what they actually told him.
That's your 3 minutes. Do you want to keep going?
I'll go one more minute. What they actually told him was to not talk to me anymore. So after they first told him not to talk to me anymore, it seemed like it was working the first couple times. He's 1 floor below me. I was on the 8th, he was on 7th. He wouldn't get on the elevator. So I was like, okay, well, great. That had an effect. This should be fine. Well, then he started getting on the elevator more and more, and he turned his back to the camera, and he'd whisper threats to me like, oh, you'll see. And one time he did it in Russian and Italian, and it was just really, I caught some of these on film. But in any case, that's a lie. In my opinion, and this is just an opinion, either statement implies the other. So, whether they actually told the truth or not, what's the matter, right? Like neither one of us should be approaching the other if we're told not to talk to each other. That's just common sense, right? So certainly I would have abided by that. I'll probably need another minute, but yeah, that's basically what I wanted to cover. I didn't see any mention of the mold that I reported in my yearly review through all of this. So I asked the investigator to subpoena for that yearly review 2 years ago. I did it there because we all talked about how written statements we think disappear from there. I told my neighbor, hey, don't worry, I reported the mold, it's on my yearly review, so they won't be able to hide that. Well, I mean, it's getting swept under the carpet. I don't know why nobody here is talking about that. It blows my mind. And then lastly, they say that I didn't get a 6-week extension when I was trying to get one. They railroaded me out of here. I don't know what you guys are up to date on and what you're not, but they tried to evict me on December 21st. I was having an increase of seizures. I gave them a doctor's note from Dr. Henninger, my neurologist, that I needed more time. They were trying to do an at-home 3-day EEG, and they would not grant me that accommodation. And then they even, I don't know if lie is the word, but they certainly pretended like they didn't know I had epilepsy. I mean, I've been there almost 8 years. I've had to request so many reasonable accommodations over my epilepsy, whether it's leaving my AC in a couple extra months or asking them to turn the heat down. I mean, I have so many incidences where they are aware of my epilepsy. So it's in my opinion, it's disingenuous at best for them to say what they said in Zoom. Those are my biggest complaints. I mean, they're getting away with lying, which has been the whole point of why I've made this complaint, because they have a history of not dealing with complaints against me, and that's one of the things I should have put in my thing. It is a part of the whole investigation. There's a similar 2019 incident where it was so crazy. I had neighbors saying you should contact the Maine Human Rights Commission because they just chose SPHA to not investigate some very, very, very serious accusations from someone where they tried to get me arrested, but fortunately the police knew the situation and said, Ryan, don't worry about it. So I didn't. I just said, I'm gonna just walk away from this. Sounds like everything's fine. Well, I think had the investigator researched that 2019 incident, well, I think there would be a very, very clear pattern of basically her playing favorites. So I mean, she picks and chooses what she investigates, and can't be more obvious. So I guess I'll stop there and take any questions that you might have. How much time do I have?
You'll have 3.5 minutes left when we come back to you. Any questions for Mr. Tinson? Commissioner O'Brien.
Yes, you mentioned it, I believe, in your letter submission, and also you mentioned it again about the mold. And how are you tying that into discrimination?
Because everybody told me that if you complain about mold, they're gonna try to move you out. I was told, let me back up. I was told since I moved in there and I was complaining about parking issues and minor things, be careful what you complain about. They will squeeze you out. That's what I was told by a bunch of elders. And when they didn't address my mold issues, a lot of my neighbors were surprised that I reported that. And they said, you reported your mold issues? And I said, yeah. And they said, well, why'd you do that? What do you think they're going to do? And I said, well, I think they're supposed to respond and do a test. And it's really bad up on the south side of that building, at least up on the top floors. We don't know if it's because of the leaks in the roof or what, but I think you guys, I'm quite sure you guys have that in this whole report. The fact that they left those bins in the hallway for like 4 months, trash cans just filling up with water, and I mean, it was crazy. And it was this plane that they took that right out of there. So yeah, I mean, I complained a lot. I was the biggest complainer in the building. I mean, I don't take pride in that. I really don't. I just, I'm one of those people that believes the squeaky wheel gets the grease. I mean, you lose 100% of the battles you don't fight. So I figured I'd been there 7 years. I didn't want to be there another 7 years with that mold issue. I think a lot of my neighbors were upset at me, or not upset. I think they were surprised because some of them said, well, hey, you're not going to do anything. It's just going to put a mark on you. Others said, oh, do you realize they're going to kick us all out of here? So, I mean, some people don't report the mold in that building because they just don't want to go. We just assume they're going to have to deal with it wherever they go. But I think I have very sensitive issues. And I know this for a fact because as soon as I got out of there, a lot of my sinuses issues got a lot better. So I know there's a serious mold issue there. All of us do up on the 8th floor. And actually, I heard there's a guy on the 4th floor.
Oh, Mr. Kinsman,
Oh, yeah,
only
no,
what's
I
in the
can't-
record.
okay, yeah, sorry.
Commissioner David.
Mr. Tinsman, in regards to the, one of the incidents with the neighbor in the elevator, the report says that director reviewed the surveillance footage, which showed complainant, that's you, grabbing neighbor by the arm and pushing him down 3 times. After watching the video, director determined the complainant began the altercation. You've seen the video?
Oh, yeah, I mean, I was
We
there.
haven't.
I was there.
Does it show that?
The guy was holding the button down for 22 seconds.
So it does show it, but you justify it. You respond and say, well, I was entitled to do that because he's holding the
Well,
button.
no, but I wasn't entitled. I didn't do what you just said. That's a lie. I never grabbed his arm. If you saw the video, you'll see that I push his hand off it. He comes back in for the button. He comes right in. He doesn't step away and say, oh, he fights me for the button. And he grabs my hands, and all of a sudden our hands are locked up.
Another question.
Can I just say one last thing? Because
Sure.
I think this is relevant. I mean, it was self-defense. I have a problem with my wrist where I need surgery on it.
Okay, I
As
got it. I hear it. You responded.
I just reacted.
You started off by saying that the investigator didn't talk to the witnesses that you wanted him to. We have professional investigators and they make decisions as to what witnesses are being alleged to have specific input. Did you tell the investigator that a specific witness had specific input to your disability claim and they did not not contact that witness? In other words, I'm asking a very pointed question about your sort of general statement. They didn't talk to the people I wanted them to talk to. Everybody says that.
I think I understand your question. Are you asking me if I related any of my
yes
witnesses to my disability?
Yes, and told the investigator that, and you're still making an allegation that they didn't respond.
I mean, no, but like I said, I've presented them with multiple letters that are on record in this investigation, and one of them was in January. My doctor wrote a letter to them asking them to please give me more time. They gave me one more day, so they acknowledged that, but they thought 24 hours was the reasonable accommodation. I would argue that's.
You're talking about the eviction, right?
Well, what it
writ of possession or something.
Whatever it ended up being. We made a deal.
Thank you.
Thank you.
Any other Commissioner Douglas?
In your opinion, what is the reason for the dispute between you and neighbor? What's the problem between you two?
Well, I can tell you that it all started on July 8th, where the guy, actually, if I'm perfectly honest, it actually started prior to that because I was uncomfortable with the guy. I had never met the guy before. He had just moved in the building, and he put a suit coat on my door. It was quite aged. I'm not going to bore you with like the really boring, the small details, but he put a suit coat on my door. I didn't know who it was at first. A week or two later, I see him down the hallway. Like, he might have never met this guy before. I don't know who he is. I just know he's a guy that just moved in the building. And he stops me and he says, "Hey, did you get the coat that I put on your door?" And I said, "Oh, that was you? Yeah, I did. Thank you." And he said, "Oh yeah, well, you know," he goes, I got it from my brother, and my brother doesn't like it. I don't know, you have kind of the same figure as him, and I think you look really good in it." I was like, okay, thank you. And I said, well, you know, to be perfectly honest with you, I said, I've been trying to clear out my closet. I have way too many clothes. So I'm probably going to just bring it to Goodwill. I said, do you want me to give it back to you? And I said, I just don't think I'm ever going to wear it. And he said, oh, no, you can just bring it to Goodwill. That's no big deal. Well, I brought that up when I tried to get protection from harassment against them. And I thought to myself, should I have really brought that up? I didn't bring that up on record and any other thing. And then he admitted in front of the judge, he said, Your Honor, can I ask him a question? And he said, yeah. And he said, well, if you took that to Goodwill, how do I have that in my closet still?
All right, so you had a dispute about the coat.
Just tell me.
I understand. You had a dispute about the coat, and you have disputes referenced.
It's not a dispute. It made me uncomfortable. I mean, he told me I'd look good in it and that I had a nice figure.
Okay.
So then fast forward to like,
You've answered my question.
oh, well, I thought you
Yeah.
wanted to know
Thank you.
what happened with
No, I'm good. Thank you. It's good.
Any other commissioner questions for Mr. Tinsman? Seeing none, you'll have 3.5 minutes when we come back to you for your sit and we'll be back up. Ms. Bruce, you have 10 minutes. Do you want to save any of your time? You're muted currently, so we can't hear you if you're speaking.
Hello, so I'm Leanna Bruce. Oh, let me start my video. I have attorney Connor Scratz here with me to represent South Portland Housing Authority today. Not sure if we have to unmute him.
Should be able to unmute himself.
You've been told that he needs to.
Yeah.
unmute.
He says he's trying to unmute
He
now.
says try. Do you think he's asking you?
We can't, for some reason, we are not able to unmute people. All we can do is ask to unmute, which Chelsea keeps doing.
Yeah.
See if he's getting any of them.
This is the best conversation. Just.
Connor, you're typing to, yeah, you're not typing to Connor.
He's sending difference.
Yeah. I'm still. I do like that.
All right, you're unmuted and there's video. Great.
All right, thank you for that. I appreciate it. Sorry, I was having an issue working from my computer here, so I'm doing it from my phone. So thank you for bearing with me there, and I apologize for any of the any technical issue that may be present on my end. But to introduce myself, I am counsel for the South Portland Housing Authority in this matter, and I just want to respond to some of the issues that Mr. Tinsman's raised here, and certainly I'm happy to answer any questions. I'd like to reserve 5 minutes, but I don't know that it'll be necessary to use that much time here. So to start with, I just want to state that it's South Portland Housing Authority's mission to provide quality housing to individuals with low and moderate income and individuals with disabilities. And we take that goal very seriously and only take action to remove individuals from housing when it's absolutely necessary. So that's never a decision that is made lightly. Unfortunately, in Mr. Tinsman's case, it did become necessary. And it became necessary because Mr. Tinsman was found to have assaulted another resident. As we just heard, that assault was captured on video. It shows Mr. Tinsman approach that resident. He has identified self-defense as the basis for this action, but the video shows that there's no self-defense implicated here in any way that people would typically use that term. What the video shows is Mr. Tinsman approaching this individual and accosting him due to what appears to be some kind of dispute over the use of an elevator. Mr. Tinsman could have walked away from that situation and reported it. He could have waited for another elevator, taken the stairs, or some other action that did not involve physically accosting this other resident. But unfortunately, that was the decision that he chose to make, which resulted in South Portland Housing Authority complying with its policy and its federal regulation requirements to take actions to initiate an eviction. So they investigated this matter and engaged in that removal process, as is, again, something that's consistent with their policies. So the facts that Mr. Tinsman's raised here regarding his prior conflict with the resident, these issues that in his most recent submission about the resident giving him the finger. It's again not relevant to the question of whether Mr. Tinsman violated Portland Housing Authority policies and whether he did so in such an egregious manner that eviction was warranted. Mr. Tinsman has now identified just in his previous comments an accusation that Ms. Bruce was engaged in picking favorites among residents. He appears and has raised this previously during this proceeding to be referring to the resident with whom he had this conflict that resulted in him physically assaulting this resident. And we obviously dispute that there was any picking favorites. That resident and has actually in another matter filed complaints against the South Portland Housing Authority that have risen to the level of Human Rights Commission. So again, we don't see any basis there for any allegation of favoritism. So for these reasons, again, I'm happy to answer any questions. But we believe that Investigator Brindley was correct in their assessment that that Mr. Tinsman had not made out a prima facie case for discrimination, and in fact cannot do so. So we respectfully request that the commission adopt the findings of this investigation report and find no reasonable grounds for discrimination. Thank you very much.
Thank you, Attorney Scratz. Any commissioner questions for respondent's attorney? Seeing none, you'll have about 7 minutes when we come back to you. Mr. Tinsman, you have 3.5 minutes if you have anything else you'd like to add.
Yes, I would just like to stress that during the Zoom, the director claimed that I assaulted her twice. Now she's claiming that I assaulted 3 times. She's claiming I grabbed his arm. I didn't do any of this. I think that was all submitted to the investigator, wasn't it? I mean, I understand if you guys haven't done it because there is a lot of evidence. So I can see from what you guys have had on your plate, you can't probably go through every little piece of evidence, but shouldn't the investigator have seen all the video? I mean,
we will hear from the investigator after we hear from the parties.
Okay, well, so I guess the only reason I'm asking that is because at some point, I think we need to put a little more weight on the people that are telling the truth and maybe a little bit less on the people that are trying to add weight to something that's not there. I mean, if you guys saw the video, I'm convinced that you would see that Mr. D'Ambrosio, like I said, doesn't just step.
Please don't use the.
Okay, sorry. I'm just so used to it. I think you guys would see that he actually fought me for the butt. He grabbed both my hands. I never grabbed his arm or anything. Once my hands were locked up, I had the guy's bigger than me. I mean, that's why I'm telling you guys it was self-defense. I didn't go down there looking for him. I've had a seizure once in the elevator already. I'm claustrophobic. They know all this. So it's the context. It's the context of them telling him not to talk to me and then telling me to let them know if anything else happens. And then I sent them multiple emails. You guys should have all those too. And they wouldn't talk to me. They didn't address him as far as I know. When I brought that up with them, they said, well, you don't know that we didn't address him. I said, well, you're right, I don't. I don't know what I don't know. You guys aren't talking to me. So I just wish they had at least said, Ryan received, thank you. We'll look into this or whatever. But I just never got any of that. And so like I keep reiterating, all the way from July up to October 24th ultimately, but October 20th was when he threatened me in Russian and Italian, and the investigator should have that on film too. I'm not so much mad at the investigator as I am SPHA still, because I had a lot of good neighbors there and I had a good life. And I don't think I should have been the one to be squeezed out. They had no interest in mediating anything with me. They said because of when I got arrested in 2020, wrongfully arrested, I might add. I was assaulted. The people that assaulted me tried to claim that I attacked them with a knife. Well, that was proven to not be true. And they tried to evict me for that. They couldn't because of the end result that ended up being filed. But they still used that on this most recent eviction. And like I just said to you, they that incident that I was getting a 7-day and not a 30-day eviction and no chance for mediation. So You know, can they legally do that? Probably. I mean, is it ethical? I don't think so. I mean, if they know that that was resolved 4 years ago and they still added on the, I mean, that, I think that shows a little bias. Everybody I've shared this with close to me says, yeah, that's certainly not ethical. So I'm gonna.
Mr. Time, wait, any commissioner questions for Mr. Tinsman? Thank you very
All right,
much.
thank you all for your time.
Attorney Scratz, you have 7 minutes if you would like to add anything else.
Thank you. The only thing that I'd like to add, the parties did go through a mediation process in this matter in December of 2023. But otherwise, the Housing Authority doesn't have anything else to add. Thank you.
Very much. Any other questions for Attorney Scratz? Seeing none, we've heard from the parties and we would next hear from Investigator Brindley.
Hello again, everyone. My name is Alex Brindley, still is. So I think, I think the facts here are pretty clear. Complainant in this case was seen on video physically assaulting neighbor. It seemed, and I watched that video multiple times, I did not see any evidence that complainant's conduct could be seen as self-defense. So in that regard, I believe the eviction claim seemed to be pretty clearly based on his conduct that day. Furthermore, during the Issues and Resolutions Conference, the complainant stated that the real reason he believed he was being evicted was because he reported mold. I will say reporting mold is not a protected activity under the MHRA, so that itself is moot. And then lastly, the final claim was a request of reasonable accommodation. Complainant stated that he requested for an extension for his move-out date that was determined in court through the mediation program. On January 26th, the complainant did request a 6-week extension from the respondents, but did not relate it back to his disabilities. In fact, I have it here. It says, I'm writing to formally request a 6-week extension to the previously agreed upon relocation deadline of January 31st. This extension is necessary to ensure I can secure suitable housing that meets my specific needs. That extension request was denied. On January 31st, I believe he did provide another letter requesting for more time. The respondents indicated that due to the severity of complainant's actions and considering that neighbor was still currently residing in the building, they could not accommodate more than 1 day of an extension to allow him to move out the remainder of his belongings out of his unit. I'm open to any questions.
Commissioner Douglas.
Yeah, so just checking the time. Good afternoon. I want to make sure we just air this out completely before we decide. This video, right? You said you watched it multiple times. Who approaches who in that video? Like, how does this conflict start is what I'm getting at.
If I were to give a play-by-play, complainant in the video is in the elevator. Neighbor is outside the elevator, sees complainant. Neighbor holds down the elevator button for 22 seconds, the complainant said. Once complainant became aware of that, complainant removed neighbor's hand off the button pretty sharply, and then they tussled for a bit. Complainant pushed him down 3 times. In the IRC, he indicated that he had to do that because the neighbor was trying to get back up.
Okay, all right, thank you.
I'm not allowed to respond to that?
Not at this time, no. Any further questions for Investigator Brindley? Seeing none, thank you, Alex. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are 2 proposed findings. Commissioner David.
I'll take them together and move that we find that there are no reasonable grounds to believe that respondent discriminated or violated, engaged in MHRA protected conduct, and the complaint should be dismissed.
Second.
Moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
So the findings are no reasonable grounds. We thank everybody for their participation, and the commission will send a letter to the parties and council confirming the results of the hearing. That concludes our hearing agenda.
Thank you guys for your time. I appreciate the opportunity.
Thank you.
Have a good one.
Okay, can I have a motion to litigate H 23-0314 and H 23-0317?
Second.
If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Great. All right.
Let's have a motion not to.
Oh, and a motion not to litigate. What is the case number on that one?
I don't know, I just closed the memo.
Motion not to litigate PA 22-0073.
So
Second. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
yes.
Commissioner Walker,
Yes.
Commissioner Sanders. Yes. Great. Okay. We are all set. Thank you very much. We